One bail in connection with appeal of 2023, Your Lordship.
Lordship,
Bail in connection with appeal for
bail in
institution.
connection with appeal in monthly leaks.
Lordship, may I permitted to mention two application for anticipatory bail. The items are running as 362 and 365 in courtroom number 29. Yes, Lordship.
Do we have jurisdiction for anticipatory bail?
Court 8. Court 8.
Yes.
In view of the detailed discussion herein above, prosecution has been successful in establishing the guilt of the appellant accused beyond reasonable doubts. Accordingly, the conviction and the sentence of the appellant is upheld and the appeal is dismissed. Period of detention suffered by the appellant during investigation and inquiry and trial shall be set off from the substantive sentence imposed upon him in terms of Section 428 of the CRPC. The appellant is already on bail. Bail bonds of the appellant are hereby cancelled and he is directed to be taken into custody immediately.
Hello.
Yes. Call the next one.
But I am appearing for NCP with Mr. Chakraborty, my lord.
For the appellant, my lord.
There was some direction, my lord, by the earlier bench for some defect in the LCR, my lord.
Well, out of 12 years, almost 10 years I have suffered.
Then
This was considered by your lordship on, my lord, 24th of March 22, and your lordships was pleased to reject the application for bail. Dismiss.
Paper book is not ready.
One second. What are the discrepancies? What are the discrepancies? Flag A. What discrepancies? Discrepancies noted by the department be ignored. Paper books be prepared within 4 weeks. Matter and be placed before this. Be ignored.
There are defects in the LCR.
Defects be removed. Further report be filed. Adjourned 6 weeks.
Application for correction, my lord. Satisfaction, my lord, would be, my lord, learned special judge Poxo Court, Howrah Institute.
In place of so-and-so, learned special judge Poxo Court, Kolkata, shall
Howrah.
be substituted. Other put a line number so-and-so, paragraph number so-and-so. Next.
Yes, my lord. I'm for the petitioner, my lord. I was handed over a copy of the report of the BSF, my lord. May I just indicate certain portions of that report?
How your client was medically treated if he were not there?
My lord, kindly, my lord. Now, my lord, first, my lord, I'd be referring to page 15 of that report. It is the case of the prosecution, my lord, that the alleged recovery seizure 2nd January at 15:10 hours. Now, my lord, page 15 states that the requisition for my medical examination is being sent. And the next page, page 16, says that I am being examined on 6:45 p.m. That is after almost 3.5 hours. So at 15:10 hours, I was there, my lord. There is no document to show.
Follow.
Not even in the arrest
Or-
memo, my signature, my lord.
Appellant contains a report. Learned counsel for the appellant petitioner contends that his signature does not appear in the arrest memo or the seizure list signature is there.
Seizure list, my lord, signature is not there. Memo of arrest signature is there.
Oh, all right. Is not there in the seizure list prepared by the police. Recovery was purportedly made by BSF personnel, and there is nothing on record to show he was present at the time of recovery of 132 bottles of fentanyl syrup. Full stop. In light of the aforesaid submission, we directed BSF authorities be added as a party respondent. Learned counsel for BSF has submitted report. He contends the BSF team had, pursuant to prior information, BSF team had raided and recovered 132 bottles of fentanyl syrup. One of the miscreants fled away, but petitioner was arrested at the spot. Soon, the recovery was noted in the records of the BSF authorities in ordinary course of business. Petitioner was medically treated. Full stop. The contraband as well as the petitioner was handed over to the local police station, who seized the articles and arrested the petitioner. Full stop. We have considered the materials on record. Full stop. Including the report of BSF. Report of BSF shows the entry shows the brief history recorded in the brief history recorded brief attention of the petitioner and seizure of contraband. Full stop. The history, from the brief history, it appears that while patrolling, petitioner and his associate were seen smuggling narcotics. Were seen smuggling narcotics in 2 plastic sacks. Though one of them fled away, petitioner was apprehended with 72 bottles of
132 bottles.
I was apprehended subsequently. Other 60 bottles were found lying.
with
Total
72 bottles of penicillin. Subsequently,
60 bottles were recovered.
so this next 60 bottles was recovered during investigation.
Gotcha.
72 bottles of fentanyl syrup. Upon apprehension, petitioner was medically treated and the case was registered. Full stop.
Now, the second point with regard to not making of any videography, my lord would kindly come to their explanation once, my lord, last page. That is in clear violation of my lord's direction. I have annexed at page 12. Especially the second guideline, my lord, wherein my lords have been pleased to note down that in case they fail to do so, there has to be reasons. After this recovery seizure memorandum was made, no reasons given. The FIR was lodged, no reasons is being given. Well, for the very first time, now they are coming up with these reasons.
We were constrained to issue a rule of contempt against their superior officers. This is when this case
January 2023.
again.
My lord's order was on June 2022. I have annexed.
We issued a rule of contempt in the meantime. We were assured that this practice will be followed.
Grateful, my lord. Grateful.
কি বললাম আমি? And handed over to police. Subsequently, another consignment of 60 bottles of phencyl syrup was recovered on the showing of the petition. Full stop. Learned counsel has strenuously argued that there is no signature of the petitioner at the time of in the records of BSF authorities at the time of recovery. Full stop. Video directions in Kalu Khan, no?
Page 10, my lord. I have to.
Directions in Kalu
Sheikh.
Kalu
Kalu
Sheikh.
Sheikh with regard to videography and or recording reasons in the event videography is not possible have not been complied. Full stop. With regard to the first issue, we note that the petitioner was, we note soon after the incident, petitioner was medically treated. This dispels any doubt in the mind of the court that petitioner may have been, petitioner was apprehended along with the narcotics. That apart, on his leading statement, another consignment of narcotics was recovered. Full stop. In light of the, it is a fact, video recording was not made of the recovery. Report of BSF shows miscreants generally attack BSF party. Hence, video recording was not done. This view, this opinion, this explanation does not appear convincing. Nothing is placed on record to show there was any threat to show the miscreants had attacked the BSF party in the present case. Attacked the BSF party in the present case. However, attacked the BSF party in the present case. Even so, such present case, full stop. The reason appears to have been subsequently manufactured to cover up the non-compliance of the directions given by this court. However, in view of the fact that recovery in the from the petitioner is not only at the spot, but also on his leadings, but subsequently on his leading statement made to the investigating agency, we do not wish to enlarge the petitioner on bail due to such lapse on the part of the investigating officer. Full stop. However, we note non-compliance of the directions of this court in so and so. Accordingly, who is the recovering officer? Deshraj. Accordingly, we direct the Deshraj Singh. The signature is of Deshraj Singh.
But page 18 of their report, 19 is the signature, SI Nesar Ahmed, page 19.
It's not the SI. The recovery is by the BSF officer.
Yes,
Inspector of BSF.
Sub-Inspector of BSF, my lord, Nesar Ahmed.
But he has not prepared the memo, has he?
17 onwards, my lord, in all the documents, his signature is appearing.
And this report is prepared by whom?
Report is by B.K. Yadav.
Deshraj Singh. Page Annexure A, 4 and 5.
Okay, Deshraj Singh.
We direct the seizing officer SI Nesar Ahmed, numbers as well as Deshraj Singh commanded 54 Battalion BSF. Deshraj Singh to show cause to file affidavits why contempt proceedings shall not be drawn up against them for non-compliance of the directions of this court in Kali.
Lord, may I submit one? Subject to your lordship's correction, my lord. The situation was different here.
We don't see anything in the report with regard to situation. Mr. Bose, if the situation was different,
I only asked, and my lord,
we don't, then you give an affidavit that you were present or not.
no, my lord, I shall comply with your lordship's
No,
direction.
no, we do not understand this desperate attempt. We would have accepted and we respect the situation in the ground level may be of such nature, which would not permit them to go through the formalities. But the laws, but our direction says, record that in the report. The report is completely silent with regard to any threat perception. If that is not so, Mr. Deshraj Singh's report is completely silent. The seizing officer's memo is also completely silent. Only belatedly you say, ordinarily there is a threat, that is why we do not comply. That means you do not want to institutionalize compliance, but you want to deinstitutionalize compliance. That we cannot accept. File your affidavits within 4 weeks.
No
15 days.
directions given from high
Within
court.
4 weeks.
But on the contrary, my lord, they have stated that no directions or guidelines given from the headquarters regarding videography. In the report, they have stated.
4 weeks. No, no, this is something we. There must be compliance. Sir. You are not passing orders just like that.
Last page tag though.
Expression. In fact, in the report, it is also noted that there is no direction given by the authorities
Regarding video recording in such cases.
regarding video recording. That is at page.
Page 22 of the report, last
At
page.
page let us get an affidavit explaining their conduct. Why this is not so. In our understanding, by the directions were already there.
Yes.
My lord, I have for the petitioner. My lord, on last occasion, your lordship has been pleased to call for a report with regard to the health status of the petitioner, my lord.
My lord, as per the report, my lord, that petitioner is suffering by perianal abscess, my lord, fistula. My lord, this is the main thing. And my lord, time to time, he is getting, my lord, treatment inside the jail, my lord. And my lord, he was referring to different medical center also in Kolkata, my lord, SSKM also. And my lord, this is the position now. Out of 10, 6 witnesses has already been examined.
Petitioner is suffering from report is placed on record. The petitioner is suffering from so and so. He had been referred to surgical OPD at surgical and medicine OPD, Murshidabad Medical College and Hospital. Would stop. He was also sent for colonoscopy at SSKM Hospital, Kolkata. Subsequently, on 19/1/2024 and 2/2/2024, he was sent for treatment due to pain in the abdomen. Stop. This after medication, he appears to be fit. Full stop. In the aforesaid facts show that petitioner requires regular medication. Full stop. Trial has proceeded.
My lord, only
My lord,
charge
only
sheet
charge fair, my lord. Evidence still let not
Uh,
examined.
Requires regular medication. Full stop. Possibility of extending his continued incarceration is causing hindrance to such to regular medication and follow-up action. He is in custody for
1 year, 8 months.
over 1 year 8 months, but examination of witnesses have not commenced. Though the recovery, that is 80 bottles of presided syrup from the petitioner, is above commercial quantity. In view of his health condition and the slow progress in trial, we are of the opinion petitioner has made out a case for bail. Allowed.
Grateful, my lord.
Yes, sir.
Obliged, my lord.
My lord, I am for the petitioner. This is my renewal application.
Lastly rejected on 10th April.
So am I. Not again. Anything is that?
This is the status.
My lord, this is my renewal application. Now I am in custody for 2 year, 2 months. And out of 13 witnesses, 4 has been examined, my lord.
How many witnesses are left?
My lord, 9 witnesses are left, my lord.
What is the recovery?
My lord, recovered is, my lord, 71 kg of gaja. 71 kg.
12th February, 13th February and 15th February, date fixed for another 4 witnesses. And on that day, all the evidences will be concluded.
All right, let us keep it on 22nd February.
My-
Petitioner submits he is in custody for more than 2 years. There is slow progress in trial. Learned lawyer for the state submit 4 witnesses have already been examined, and the remaining witnesses shall be examined in the schedule fixed between 20th,
12 to 15.
13th and 15th February.
12th to 15th February 2024.
Yes.
To test the bona fides of the prosecution, we fix the matter on 21st February 2024. Further report we filed on that.
Great.
Next.
My lord, I am for the petitioner.
Yeah, for the-
This is renewal of application, my lord. After 1 year, my lord, I am in custody about 2 years, 6 months. Last 3 dates, my lord. 2 dates, my lord. Witnesses are not.
Out of
8,
8, 5 have already been examined, my lord. He
3,
has
my lord.
annexed the outer sheets, my lord. Trial is going on.
We'll give 6 months conclude.
Yes,
Petitioner is in custody for 1 year 6 months. He submits there is
2 years, 6 months.
2 years 6 months.
Yes, my lord.
What is the quantity recovered?
100 bottles of NCD, my lord.
How many witnesses have been examined? 5.
5 out of 8.
All right. Petitioner is in custody for 2 years 6 months. He submits there is inordinate delay in trial. He prays for bail. Learned lawyer for the state contains 5 witnesses have been examined. We have considered the materials on record. Though quantity of heroin, though narcotics recovered from the petitioner is above commercial quantity, that is 100 bottles of presided syrup, we are of the opinion there is slow progress in trial. Petitioner is not, and 5 out of 8 witnesses have been examined. Petitioner is not responsible for the delay. Under such circumstances, we are of the opinion petitioner is entitled to bail on the ground of delay. Bail prayer is not fettered, so answer.
Deeply obliged.
Next.
My lord, I am for the petitioner. My lord, 7 months, 20 days in custody, no chemical report. My lord, 7 kg.
Yes, Sonali class, no chemical report. Within 7 to 10 days, all chemical report come. What happened? What 7 months? Why are you sitting over chemical report? Yes.
Can you adjourn it for 1 week?
1 week.
Grateful. My lord, I am for the petitioner. My lord, I'm in custody for 2 years and 10 months. My prayer for bail was rejected by this honorable court on 30th of January 2023 with a direction upon the trial court to expedite the trial. On 11th of August 2023, this honorable court in a revisional application was pleased to direct the learned trial court to fix schedule of 3 dates in every 60 days and the SP of police to ensure presence of witness. This order was passed on 11th of August 2023. My lord, yes, it was communicated on 22nd of August 2023. My lord, thereafter, only one witness was examined. In total, 3 witnesses had been examined out of two years and 10 months.
For more than 2 years and 10 months, he submits there is delay in trial, he prays for bail. Submits there is delay in trial, he further submits a learned single judge of this court in CRR so and so had directed the trial court to page that CRR order.
My lord, CRR order, page 9.
Page 9. Had directed the trial court to fix schedule of 3 dates once in every 60 days and conclude the trial within a reasonable date. Full stop. In spite of such direction, only 3 witnesses have been examined till date. He prays for bail. Learned lawyer for the state contents trial is in progress. We have considered the materials on record. Though 100 bottles of fentanyl syrup was recovered, trial is progressing at a tardy pace. In spite of direction given by this court in CRR so and so, only 3 witnesses have been examined till date. Prosecution proposes to examine 12 witnesses in all. Under such circumstances, we are of the opinion there is little possibility of trial concluding in near future. Same order. Allowed. Bail is fettered, not fettered. Huh? Next.
My lord, I am for the petition.
My lord, I am appearing on behalf of the
My lord, my prayer for bail was rejected on 4th of November 2023. My lord, thereafter, only out of 13 witnesses, my lord, only 3 witnesses.
November 23, we have rejected. We will allow your bail prayer in January. February.
My lord, I am in custody for 2 years and 3 months.
Maybe, so what? Bail prayer of the petitioner was rejected in November 2023. There is hardly any change in circumstance since then. Hence, bail prayer is rejected.
Grateful.
Grateful. Maybe. सुबह में जाएगा बाजार
My lord, on 23rd of March, my lord, the BSF personnel took 2 persons and hand over to the police station with the injured condition. So for the charge sheet is speaks about the same. And my lord shows that there was a recovery of 298 bottles of fentanyl, my lord. Subsequently, my lord, other accused person has been charge sheeted in this case. They were on anticipatory bail. I am not on the same footing, but my lord, my humble submission before your lordship, my lord, kindly consider during that period, neither any videography done, nothing. My lord, first, second, my lord, regarding the expert, the FSL report, my lord, kindly see, my lord, that
petitioner
two-
submits
two report has been come, my lord.
Next date is fixed on 5th of April 2024 for execution of the attachment order in respect of one of the co-accused who is absconding.
Petitioner contends that BSF personnel had manhandled them and they were falsely implicated in the case. It is also contended there was no videography of the incident. There is discrepancy in the FSL report. He prays for bail. Learned lawyer for the state contends petitioner.
But there are 2 petitioners.
Petitioners were smuggling
Fentanyl syrup, my lord, for
were
exporting to
smuggling
Bangladesh.
fentanyl syrup across international border. BSF personnel apprehended them. There was a skirmish. apprehended them and recovered 298 bottles of fencicillin syrup. There was a skirmish as the petitioners tried to flee away. Hence, they were injured. Full stop that. We have considered the materials on record. BSF personnel had apprehended the petitioners while they were smuggling 298 bottles of fencidril across international border. It is though petitioner content they were manhandled, comma. It is the prosecution version that they tried to there was a skirmish as they tried to flee away. Full stop. Under such circumstances, failure to this resulted in injuries on their this resulted in injuries on the petitioners. The circumstances which were prevailing at the spot due to the petitioners trying to flee away may have stood in the way of the BSF personnel to videograph the recovery. Full stop. Issue with regard to discrepancy in FSL report is a question of fact which requires to be thrashed out in trial. However, in light of the large volume of narcotics recovered, which were being smuggled across international border, and in light of statutory restrictions in the 37 of NDPS Act, we are not inclined to. Next.
On behalf of the petitioner, the accused person is behind the bars for more than 1 year, 11 months, and 13 days. The total number of witnesses to be examined are 10, and PW1's chief examination is going on and not concluded in date.
Heroin had been recovered from the sole possession.
Examination of chief of PW1 is not completed till date.
How long you are in custody?
1 year, 11 months, 13 days to be specific.
The next date is on 12th February, madam.
One-
Further examination.
1
341 kg heroin, madam.
kg, and you have said 1.34.
No, my lord, it's a typographical mistake. The kg is missing. I apologize for
1
that.
kg is becoming 1 gram. We have considered the materials on record. Over 1 kg of heroin was recovered from the petitioner.
No, my lord, the
Full
kg
stop, yes.
was missing.
We have trial is in progress in view of the aforesaid circumstances and statutory restrictions under 37 of NDPS Act. We are not inclined to grant bail. Trial court is requested to expedite it.
14, I have for the petitioner, my lord. This is a renewal of prayer, my lord. Last time it was rejected by this honorable court on 7th November 2022. My lord, out of 30 witnesses, my lord, only one witness has been examined.
My
My
lord,
lord,
out of trial is in progress, my lord. Out of 20, there is
30.
29 charge sheeted witness, my lord.
30 witnesses, my lord. One witness has been completely examined. My lord, I have 768 days in custody. If your lordships kindly consider these as well.
My lord, there is 29 charge sheeted witness. 3 have been examined already, my lord. Next date is fixed on 9th February 2024 of
My lord.
PW4, my lord. My lord, there is a recovery of 1037 grams of morphine along with 925 grams of acidic and hydride, my lord, from the house of this petitioner, my lord.
Well, 29 witnesses will be brought down to 10. The investigating officer will make that prayer tomorrow. Tomorrow is the date fixed in the trial for examination of PW.
Shamim Malik was also a co-accused.
Yes.
Shamim
From his statement,
From
his
his
house was raided, and from his house, 1.037
grams.
no, 1.037 kgs of ganja, heroin was recovered.
only one witness has been examined.
Three.
my lord, I have instruction only one, but since
And
that's
witnesses have received threats.
my lord, that
And we ordered that. The co-accused bail prayer was rejected.
In December 2020.
yes, yes.
No, co-accused has been rejected. Co-accused.
My lord, I am for Zaber Ali Sheikh, my lord.
Ah,
I am for Zaber Ali Sheikh, my lord. My prayer was rejected on 7th.
fine. Shamim Malik was rejected in December.
My lord,
So how do you differentiate your position from Shamim?
my lord, since my
Witness.
Then
My lord, I am under custody, my lord. There is no question of threatening from my end, my lord. My lord, I have
Shamim was
700
also in custody.
my lord, that information I do not have since my lord learned.
We have that information. We are offering you the information.
Lord, 760 days, it is.
Petitioner is in custody for 760 days. He submits there is slow progress in trial. He prays for bail. Learned lawyer for the state opposes the bail prayer. It is contended from Shamim. How much was recovered?
That is all 3 kilos.
30 packets, 100 grams. That is 3 kilos. We have considered the materials on record. 3 kilos of
No, that was already recorded on the earlier order of your lordships.
we are repeating that in our disorder. 3 kilos of heroin was recovered from a vehicle. Co-accused Shamim Malik was present in the vehicle. Pursuant to the statement of the said co-accused, petitioner was arrested. On interrogation, you are Jaber.
My lord.
কি বললাম petitioner in the pursuant to statement of Shamim, residence of the petitioner was raided and
1.037
1.037 kilos of morphine and other controlled controlled substances to prepare narcotics was recovered. Full stop. One of the trial is in progress and 3 witnesses have been examined. 1 witness has received threat. Full stop. Under such circumstances, bail prayer of co-accused Shamim was turned down in 2023, in December 2023. Hence, we are not inclined to grant bail to the petitioner. We request the trial court to render necessary protection to witnesses and proceed with the trial with expedition.
My lord, 59 for the petitioner, my lord. The petitioner is in custody for 4 years, my lord. He's in custody since 26/12/2019. My lord, co-accused are already on bail.
What is the stage, Mr. A?
My lord, PW1, cross-examination of PW1 is fixed today and is going on, my lord.
My lord, 9 more witnesses are yet to be examined, my lord. There are 10 total witnesses.
Petitioner is in custody for more than 4 years.
He is a resident of Manipur, my lord. The chance of absconding is
You give why so such why there is so much of delay?
My lord, I have prepared the list of dates. My lord, can you see after your lordship's order, my lord? How many dates?
March 2023.
After your lordship rejection order, that is, my lord, these are the.
Yes, why don't you say, sir, the first line is important. Co-accused prayer was rejected. Syed Kaju Diwan.
Yes.
And we had directed the completion of trial within 1 year. Right.
That several times, my lord, PO was on leave, my lord.
That 1 year has lapsed.
No. Then
Bail prayer of petitioner submits. He is in custody for 4 years. He prays for bail on the ground of delay in trial. Learned lawyer for the state submit bail prayer of accused was rejected in November was rejected in CRM so and so NDPS 424 of 2023, and the trial court was directed to conclude trial within 1 year. The time prescribed by this court has not expired. We have considered the materials on record. Petitioner and co-accused were involved in interstate trafficking of narcotics. Large volume of Yaba tablet and 1.07 kg of heroin was recovered from them. Bail prayer of co-accused was rejected in March 2023, and the trial court was directed to conclude trial within 1 year from the date of communication of the order. Order has been communicated to the trial court on 17 April. Said order was communicated to the trial court on 17 April 2023. The time prescribed by this, proposed by this court to conclude trial cannot come to an end. Under such circumstances and in view of the nature of the offense, and as petitioner is a resident of a different state, we are not inclined to grant bail.
My lord, please, sir.
Different state, and there is a chance of abscondence if released on bail.
Lord,
Next.
I was request for expeditious of the trial, but
All request is already there. Why? Because you don't know, and you suddenly reveal, and then that will be cited in.
Lordship, I am
Institution. All prior allowed in connection with a particular case must be documented before. Then you know the history of the case. You don't know.
Lordship, I am for the petitioner, my lord.
Clerks,
My lord, allegation under section 22C of the NDPS Act, Lordship. I am in custody for 615 days, 1 year, 8 months, Lordship. 75 bottles of fentanyl, Lordship. 17 witnesses are there. Only 5 witnesses has been examined. There was a order of the revisional court of this honorable court, Lordship. That order has been communicated. After that, also witness, Lordship, I have annexed. That is P2, Lordship. And I have communicated the order, Lordship, on. It would be evident from the order sheet, Lordship. On 16/8/2020. Lordship, I have annexed, Lordship, P2. CRR 2893 of 2023, Lordship.
Lordship, as per the direction of this honorable court, trial started in the second week of October, and the next day, 6 witnesses were examined, and next date is 15th, 18th, and 19th of March.
Lordship, as per my instruction, 5 witnesses has been examined, Lordship, only. And after communication of the order also, he was in leave, Lordship, and witness was not present. I have annexed all the certain order of Lordship.
There was a direction to start the trial in the second week, and the learned court will be at liberty to fix schedule consisting of 3 days.
Correct. Now,
schedule of
August,
every 3 months.
see, Madam, page 19. Order is communicated on 16/8. The judge fixes the date in October, right? You don't lead evidence. Right?
As per the order, the trial.
No witness examined on that day, right? Again, December, local bar resolution, no witness examined. Then in 20th of December, 2 witnesses have been examined. So in all, how many witnesses are examined?
17.
Total 17.
How many have been examined?
5 witnesses.
So after this
My
direction,
instruction is 6 witnesses.
after this direction, 2 witnesses have been examined. Correct?
After this direction, trial started, and
So how can there be
5
5 witnesses examined? Where is the next schedule? When was the next schedule?
Next schedule is
18th of March and 19th.
Your order sheet after 2012-2023, what are the orders?
Lordship, now on the bottom of the order, Lordship,
Bottom of the order.
15/3/24,
So
18/3/20.
PW1 and 2 only examined.
Lordship, I have the PW3/4 also had been examined.
Then when were they examined?
They have examined on 1,
5 is examined on
2,
20th of December. But
3 examined on 11th day of October 2023, Lordship. And 4 has been examined on the same day, 20th December, Lordship.
October examined.
And on
So order sheet is coming.
may I hand over, Lordship?
Once.
I have the copy.
Mr. Public Prosecutor, see the order sheet and see the evidence. The order sheet does not tally with the evidence.
Perhaps your lordship will kindly come to page 20. That the order dated 11th of October 2023. PW2 and 3 are examined and cross-examined in full. But your lordship will again come to the order dated 20th of December 23 appearing at page 22. Here it is again said PW1 and 2 are examined.
Yes, Lordship.
That is
There
what
must have been a typography.
some error is there. So 2 and 3 are examined. I think this should be 4 and 5.
2 and 5.
4 and 5. Right. All right. 1 year, 10 months.
Yes, Lordship. 1 year, 10 months.
Another 6 months. Wait. Till finish.
1 year, 8 months. Lordship, kindly consider, Lordship.
Considered.
Lordship, after the order of the revisional court, Lordship,
Very good progress.
Lordship.
5 witnesses.
Lordship, kindly, Lordship.
Please see the divisional.
First sheet,
Very good progress. October examined 2, December examined 3, 5 witnesses examined, March they are fixed remainder. Give a last opportunity in March, let them finish it. If they cannot finish it, we'll consider it. Don't press it. Not pressed.
Your Lordship's observations, Lordship.
We are not saying anything. Just wait for March.
Right.
If they cannot, we'll consider.
ওর নাম লেখো নেহার ওই নাম আইটেম লিখতে গ্রেটফুল Lordship.
Not 6.5 kgs of ganja was recovered from 2 other persons. They are on bail. Charge sheet has been submitted. Petition, no. Admittedly, I am Indian. The charge sheet has been submitted. And
you are dealing with foreigner, international trader.
No, those persons who are putting charge of 14 foreigners against the bailed out.
You are international.
No, I am in custody for 57 days and my name transpired in the statements of the arrested accused.
Abscond for 2 years. Now we are told that the Himachal Pradesh ganja price has gone down. Ganja from Odisha is more valuable. Huh? The potency java. Malana is now down. The price is going down. Some simile or something. Mr. Public Prosecutor was reading that Malana is going down now. Rate of Malana is going down. And from Odisha, now the better marijuana is coming. It is from the Shimlipal region and all. So you should have rate chart, which is better international trade. Marijuana is always international because there are problem with marijuana now is some parts of the world they legalize marijuana.
Yes, Thailand. Thailand, it's just like
shops,
tea stalls. Cafes and everything has opened up. Maybe costly.
No, the problem.
Just like Amsterdam. I don't know the foreigners, the Western people come down to India to
Israelis.
have this type of intoxication.
Correct.
Now the Indians are buying it from US.
The Indians are, we got a case. What happened was, I think Shoposhati Banjo, someone was moving. This man is purchasing from the states in the regions of United States where the
It's legal.
marijuana trade is legal. And what he is doing is, he's doing it on the dark web with bitcoins. And the courier is supplying it here and he is distributing from his residence. You appeared now? Mr. Nondi appeared. California weed. And the argument is California weed is legal in US.
The United Nations to decontrol at least marijuana from the.
Or we control marijuana. Like bhang.
Made a recommendation.
Like bhang.
Yes.
So it will be regulated.
Whatever your lordship does.
It will be regulated, not prohibited. Even now, marijuana is regulated. You can have a license.
They used to have a license.
Earlier, you remember those shops?
License.
Even opium license was there.
Before 92. This has been stopped in Bengal.
Oh, in Bengal you don't have
They
it.
have been given this country spirit license instead.
So the problem in India is again a different problem. You have in US states where they have deregulated marijuana. You have states in India where even liquor is prohibited. So you understand how the things have become so lopsided. And the trade, therefore, whatever happens is whenever there is prohibition, there is illicit trade. You understand the entire. Exactly. Yeah, it is happening. In Mr. Public Works, what has happened? This fancy drill trade. Why this fancy drill trade into Bangladesh? Fancy drill prohibited in Bangladesh.
Because previously it used to be.
It is a medicinal product in India, prohibited in Bangladesh. So what happens is it is lucrative to illegally import. Where your client is Gaja, but he can diversify if released on bail. His name has transferred. Yes, any recovery from him?
No.
No recovery from him.
He was
What is he
abscond
doing?
for-
Harboring those people.
Correct?
Harboring them. These foreign, these Bangladeshis.
No, it's not Bangladesh.
No, I'm saying what is his complicity?
No, not filter. The from 2%, the
Contraband was recovered.
That 2% purchased the same from him.
That is statement of the no recovery from his residence. No villager statement or local people statement. Petitioner is in custody for 57 days. No narcotic was recovered from his possession. He prays for bail and a lawyer for the state submit. Petitioner is dealing with narcotics from with Bangladeshi nationals. They were arrested with 6.2 kgs of ganja. We have considered the materials on record. No narcotics was recovered from the petitioner. His complicity has transpired from statement of co-accused before police officer, which are inadmissible in evidence. Under such circumstances, we are inclined to grant bail to the petitioner. Now, they can rebut me. It's below commercial. Yes. Sukanto Mondol.
My lord, the last 5 years, your lordship's order has not been complied with. Suddenly, the pressure from this bench, my lord, police, the examination date was fixed today. But my lord, suddenly police brought the girl's mother on 5th and 6th and examined her.
Very good.
But after 5 years, my lord.
That is very true. Why did you pray for bail? You prayed for bail, we ensured your trial.
My lord, your lordship directed.
Victim has been examined.
No victim was.
1 week, adjourn 1 week.
Advocates are usually not executed.
No.
The PP has changed. The PP has on first day. Initial PP died. Thereafter, your lordship will find he learned advocate absconded. The legal aid services authority was directed to be represented. My lord, many occasions he was not present even.
The advocate. But now he is a representative.
Totally, the fault is not on the prosecutor.
No, but then let the victim be examined.
Adjourn it for 1 week.
1 week.
My lord, my learned friend is not correct, my lord.
Correct.
My lawyer.
Please.
Last occasion, on 5th and 6th, our lawyer was examined.
I'm not saying on the last occasion.
Yeah,
That, my lord, kindly see the
that is one of the rare exceptional dates when your lawyer came and was kind to cross-examine with.
Kindly see the copy of the order. I have given all copy of the order, certificate copy. Kindly see, my lord.
Now be kind enough to cross-examine the victim. Then we will see the evidence of the victim and the mother and consider the bail application. We are informed that the victim shall be examined shortly. Under such circumstances, we adjourn the hearing of the bail application for a fortnight. There is a batch of lawyer in
Report filed by the LRB.
report by LR discussion. Batch of lawyer whose job to seek action.
এটা নিও না ভাই, জজের কপি। এটা নাও, এটা এটা পুরনো, এটা পুরনো।
My lord, for the petitioner, my lord, this for the allegation under 376 L of IPC. I am in custody for more than 4.5 years. Sole
This is the
accused.
status report, my lord.
Trial has already been commenced. Out of 13, 5 witnesses has been examined. Out of 5, 3 witnesses is already being cross-examined. Victim girl is examined and cross-examined. There is a disimpropriety in one of the statement in cross-examination by the victim girl, which on the last occasion I have pointed out.
Where is the evidence of the victim?
Page 44 is the cross-examination.
We want to see the chief first before we go to the cross-examination.
Page
43 is the chief.
Yes, what do you want to show in cross-examination?
My lord, kindly comes to the last sentence of the page 44. It is true that due to some misunderstanding, the de facto complainant has filed this case. On the previous occasion,
De facto complaint.
my lord, it is elder sister of the victim woman. On the last occasion, your lordship was held in while adjudicating the previous bail application. This court held that the victim is somewhat mentally ill.
Yes.
But my lord, this statement is construed as a victim statement, which, if not considered here, it should be prejudice my defense. And my lord, at this moment, the trial is commenced. There is no scope to tampering with the evidence or.
How many witnesses left?
My lord, 13.
There are total 16 witnesses in the charge sheet, my lord. 5 have been completed. Going on, ma'am.
The appellant is in custody for 5 years. He submits there is inordinate delay in trial. He prays for bail, and a lawyer for the state submits report. We have considered the materials on record. Most of the vulnerable witnesses, including the victim, has already been examined. Full stop. Prosecution proposes to examine 15 witnesses.
16 witnesses have been
16 witnesses in all. Petitioner has suffered incarceration for more than 5 years.
More than 4.5 years.
For more than 4.5 years. There is little possibility of trial concluding in near future. Under such circumstances, we are inclined to grant bail to the petitioner, subject to conditions. Petitioner, while on bail, shall not enter district of North 24 Pagnas, except for attending court proceeding. Provide the address. Next.
এটা সেশন কোড বাড়া
May it please your lordship. I am for the petitioner, my lord. Who on the last occasion had directed, my lord, the state to file a report. My lord, this was my second application, my lord. 1 year, 225 days in custody. My lord, the victim had refused medical. My lord, there are almost 13 witnesses.
Let the victim be examined.
Lordship, the victim girl and her mother has been examined. Now, Lordship, the father's for the father's examination, 23rd of February is fixed.
What is the evidence of the victim?
That I never
Get the evidence. When is the father's
is that?
examination? 23rd. So we are keeping it after that. In the meantime, place the evidence on record. We are informed. Learned lawyer renews his bail prayer. We are informed examination of vulnerable witnesses are in progress. Next date has been fixed on 23/2/2014. Under such circumstances, we direct the matter to appear on 5th of March 2024. Status of the report with regard to status of proceeding be filed. Evidence of the vulnerable witnesses shall also be placed on record.
I'm grateful. DPO.
My report may kindly be.
Report is kept. 21.
I am for the petitioner, my lord. So there's a direction to status report of the trial, my lord. On the last occasion, no witness present, my lord.
Victim girl examined.
I've already stated in my petition, my lord. I have the certified copies. 164 after rejection of the prayer of the present petition.
Notified.
There's a direction.
Yes, notified.
They have also notified.
I give in the report.
After rejection, my petitioner's prayer for bail in the last year. Thereafter,
Where is the evidence of the victim? What is it, the age of the victim?
6 years.
6 years.
Yes.
Evidence of the victim is placed on record. Her evidence incriminates petitioner in the offense of penetrative sexual assault. Victim is a 6-year-old girl. Examination of her relations are in progress.
No, my lord.
Yes, yes.
No, my lord, kindly say the entire order sheet, my lord. Have it annexed, my lord. On last 10 days.
Others are yet to be examined.
That is what
Yes, that is why court is.
Relations are awaited in view of the gravity of
18
the
witnesses, my
offense.
lord.
11.
20 years. 20 years. This offense 20 years now. So 18 witnesses tell us after 2 years. After 5 years. Before that, nothing. We are, and the stage of the proceeding, we are not inclined to grant bail at this stage. We request the trial court to conclude the trial, preferably within 1 year from the next date fixed for recording evidence. Unless you can improve his presence, will come out.
Sorry.
Are awaited.
Yes.
Are not
My lord, victim has been notified.
Are not complete.
My lord, victim has been notified. I'm fine.
Lordship, this petitioner is in custody for 501 days. There are 24 witnesses. Only the victim lady has been examined. And in her examination in chief, she has said that this petitioner was not present. I'll draw your lordship.
Evidence of the victim.
Lordship, 53. I'll draw your lordship's attention to running
Has
page
our
50.
cross-examination been complete?
My lord,
Lordship,
56.
50.
My lord, kindly see page 56. When the judge asks some questions, my lord, she remained silent, my lord.
Lordship, I'll draw your lordship's attention from 53 onwards.
Kindly see 56.
How long you are in custody?
Lordship,
Custody.
How long are you in
501 days.
custody?
501 days as of now. Lordship, in her both in her evidence, in her chief and in her cross-examination, she has stated only one accused person, one Mahadev, who was there, who has received her and who was present. Has categorically stated that this petitioner was not present. Lordship,
This evidence exonerates the person. We have report is placed on record. In spite of notice, victim is unrepresented. Petitioner contends that the victim did not implicate him in the crime. Learned lawyer for the state produces the case diary. We have considered the materials on record. We have also gone through the evidence of the victim. She has not supported the prosecution case against the petitioner in view of the aforesaid and the materials on and the period of detention suffered by the petitioner. We are inclined to grant. Next. 500 over 500. Next.
May it please your lordship. My lord, the 156.3 mentions Ujjwal Dash. I am Utpal Dash. I was arrested. In the charge sheet, I was given the alias of Ujjwal Dash. Thereafter, there was a TI parade, my lord. In the TI parade, the victim did not identify me. My lord, then the police, in order to cover up, my lord, say that the two identities are different and they discharge Ujjwal Dash while retaining me as an accused. On that basis, the learned magistrate has also discharged Ujjwal Dash. But the basis of the discharge was that I was not identified in the TI parade, and I'm the primary accused is absconding. Nothing has progressed in the trial. I've paid for 207. That was also not given to me.
But we have intimated the victim. Now, my lord, last rejection, my lord, would kindly come to page 8 of their application. This point was considered, my lord. Now, what has happened? This is the 164, my lord.
That subsequent to the 164, the TI parade was held.
Yes.
Petitioner contends that victim had not identified him in the course of TI parade. He renews his bail prayer. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Statement of the victim recorded under 164 CRPC shows that she was raped by one nearby and unknown accused. Full stop. Identification during TI parade examination is not substantive evidence. Victim is yet to be examined. Under such circumstances and in view of gravity of offense, we are not inclined to grant bail.
Only the main accused is absconding, and for that, 207, even my 207 application has been rejected. The main accused is absconding. That order is annexed. That's on 27th of December.
Trial court shall take delay in the matter is due to abscondence of co-accused. Trial court shall take necessary steps. Has the case been committed?
No,
Magistrate shall take necessary steps to ensure attendance of the absconding accused, and in the event his attendance cannot be ensured in spite of exhaustion of processes, to declare him proclaimed governor and proceed with the case. Next.
Respected to Lordship's direction, man, for installation of the minor witnesses. Installation, my lord. Of those two, my lord, the two eyewitnesses were put in the home, and thereafter, my lord, their depositions were taken. So, your Lordship, you kindly see the deposition of the first 8-year-old boy, the brother of the victim. It's categorically, my lord, corroborated and stated, my lord, that the mother and, my lord, the half paramount.
Yes, where is Abu Hossein Singh?
Three days of cross-examination, my lord, will not.
Cross-examination going on.
My lord,
So
it's going on.
the next day of
That is, my lord,
cross-examination is
PW3.
tomorrow, 9/1/2024. I'm for the accused person number.
Want the cross-examination to be completed tomorrow. Please ask the prosecutor and inform the judge. One adjournment, your bail will be cancelled.
PW2, my lord, 8-year-old. He has categorically stated, corroborated, my lord, the 164 statement. And when he was put a question, "Well, do you want your mother back?" He just kept mum and started crying.
And he had also categorically mentioned in the cross-examination that he was subjected to intimidation by the police and the opposite parties. It is in page number, the second last page of the cross-examination.
That the trial court will see it in the totality of circumstances. Whether erasing away influence of a accused is tutoring, it has to be seen. Yes. You filed an affidavit. How on an affidavit bill can be granted? How on an affidavit bill can be granted?
I have seen that order.
Then on an
But on the
affidavit bill
strength
is
of an
granted in a
affidavit-
murder case.
And my lord, 164 statement of the
Mr.
child
Chakraborty,
was
we are
there.
not going into it if you are not hindering the trial already.
My lord,
But we want you to file an affidavit. In the meantime, we are adjourning the matter. Let the other witnesses be examined and the CRR order, opposite party accused, Mr. Chakraborty appears. He seeks time to file affidavit. Affidavit be filed on the by the adjourned date. Matter will appear 2 weeks hence. Trial court shall proceed with the trial of the case. Evidence adduced before the trial court be produced before this court. Trial court shall also see that the vulnerable witnesses are protected. Extra.
PW2 is a minor, my lord, was kept in the home. And thereafter, after his examination, my lord, he has been let out from the home.
Right. No parties shall cooperate with the trial court.
Deeply
May it please, your lordship, I am for the petitioner. Allegation under main section 326, 307, fight between two neighbors. I am in custody for 63 days. Arrested on 6/12/20.
Head injury, my lords, by
Consider the materials on record, though the injury is on the head, comma, whether though the injury is on the head,
this page onwards.
nothing is placed on record to show that though the injury is on the head, it appears to be superficial and internal organs had not been damaged. Full stop. Under such circumstances, and in view of the period of detention, there is no chance of abscondence under such circumstances, and in view of the period of detention suffered by the petitioner, that is how many?
63 days.
63 days, we are inclined.
I am highly obliged.
Bail application.
Thank you.
Because of these things we have to take. See that judgment. Well, is there anything? And control and dictate many times. Something like this. Knowledge. It's very difficult to work in discussion with you. After discussion में interfere करो. Allow the discussion to flow. Yes, you know, and you make that it's sort of and you circumstances people outside of the yes, offensive. Yes, Mr. Apollo
My lord. My lord, the renewal prayer. My prayer was last rejected on the 21st of February 2023, my lord. My lord, I have annexed all order sheets. The public prosecutor was not appointed. At page 19, my lord would find that the judge records, though the accused persons are behind the bar for more than 2.5 years, but the trial in the case could not begin due to non-appointment of the counsel by the TM to represent the state. After repeated orders, the learned counsel for the state appointed and appeared to pray before the court. Thereafter, my lord, repeatedly the public prosecutor sought for time. The last order, my lord, charge has not been framed. I am in custody for more than 3 years. The last order, my lord, the learned state prosecutor had sought for time, saying that the CD is in the trial court. So the bail hearing could not take place. The learned public prosecutor at the trial court has sought for time, saying that the CD is in the high court. I am in custody for 3 years, 15 days. 4 out of the 6 persons facing trial are on bail, my lord.
14 witnesses.
Well, the last time when this matter was taken up, I have stated that perhaps it was taken up on first. I have stated second is the date for framing of charge. Accordingly, I have written the original case diary for the charge to be framed. Now, in spite of that, Malad will kindly look into the conduct of the learned public prosecutor over there. I have asked my investigating officer regarding that, but the investigating officer has stated that the photocopy was, he said, I don't need the original, you give me the photocopy. The photocopy was sent to him. In spite of that, this order, he has taken adjournment saying that the original case diary is in the High Court.
But the original case diary had.
But the original case diary is lying with the investigating officer. When he asked for the original case diary to be sent to him, he said, no, I will be doing with the photocopy. Original is not required. And after that, he has stated that the original case diary is there.
Petitioner contends that.
And the person who are on bail are on statutory bail.
No, 2 are on statutory, 2 by the learned sessions judge. But I am not seeking parity with them.
Your parity prayer was rejected. Way in 2020. Contents he is in custody for over 3 years. In spite, charge has not yet been framed. Learned at additional public prosecutor. Contents date for consideration of charge was fixed on 2/2/2024. Full stop. Case diary had been remitted to the trial court for consideration of charge, but for reasons best known to him, learned public prosecutor in charge sought adjournment on the ground that the case diary is lying in this court. In light of the aforesaid submission, we direct the learned public prosecutor in charge to submit affidavit why he did not cooperate with the trial court, why he did not cooperate with the trial court for framing of charge on 2/2/2024. Department shall communicate order to the public prosecutor in charge. Please give the name of the public.
The name is Mr. Piyush Kanti Guru.
Shri Piyush Kanti Gupta. Stop. Matter will appear one week hence.
Oblige me, that's. One week. Great.
My lord, this is my matter, my lord. Yesterday, my lord, have heard this matter, my lord.
Yes, yes.
State took time to produce the direct evidence against me. Against my claim there is no direct evidence.
That's in together.
Yes.
9, 10 and 37. Lordship,
1937. 10, 19.
10, 19 and 37. Lordship kindly consider.
19,
10, 19 and 37. But your Lordship kindly see the last or middle portion. First, he has heard the murder, but thereafter, what he has stated.
that we are seeing.
And his name is Prakash. Petitioner's name. Then 19, then 37. কবার রিজেক্ট হয়েছে?
3 বার হয়েছে। লাস্ট হয়েছে 12 মে।
And considering this, his prayer has been rejected thrice. This is the 4th time.
$37.
37. Last rejected in the month of May.
And any other circumstance apart from this? There is motive and they were seen talking
Yes.
in the earlier night.
And the victim, my lord, actually, my lord, he protested the, my lord, unauthorized
Shade construction.
He's a social worker. He's a social worker. He was a social worker.
We have rejected Shiv Kumar in November.
Kumar is the principal, my lord. He is the my
No,
father.
no,
My lord,
There is no principal, no vice
my lord,
principal.
kindly there is only one statement, my lord. Caesar witness statement, my lord. Once Perus, my lord, the Caesar witness statement.
Caesar witness nothing.
My lord, at the time of Caesar, my lord, there is no direct evidence. Only the
Direct
thing is, my lord, there is no direct evidence. And my lord have rejected the prayer in the month of May. And
November.
no,
Shiv
if
Kumar.
one is, my lord, kindly consider one, my lord.
Price rejected in the month
My
of
lord,
May.
kindly see my annexure P2, page 10, my lord. Since 2023, my lord, learned appointment for the public prosecutor.
No.
Already
My
appointed.
lord, I have. বলতে দিন তারপর কোথায় যাবেন? Kindly see page 10, 10 onwards, my lord.
When is the date for consideration of charge?
That
28
report
March. 28 March.
28th March.
Yesterday filed. also.
My lord,
Yesterday report filed.
Kindly see, my lord,
How long you are in custody?
I am in custody for more than 1 year, 4 months, my lord.
Wait till March. If charge is not framed, come up.
My lord.
Petitioner contends that there is no direct evidence connecting him with the murder. He renews his bail prayer. Done a lawyer for the state content. Date has been fixed for consideration of charge in March 2024.
Application will be pending.
In view of the aforesaid submission, petitioner chooses not to press the application at present. If the charge is not framed or charge is framed, you come.
Applies to them.
Next.
My lord, this petitioner, he is shown arrested in this case. My lord, he is standing on the same footing with other co-accused persons granted bail by this honorable court. My lord, page 15 and page 18.
How long you are in custody?
My lord,
These
4 months.
person
4 months.
As a series of antecedents of 43 cases I have placed it. My lord, on on 6/2/2024, my lord was pleased to reject the application of one Rana Mondol. From the statement of Rana Mondol, it appears that this person is the prime man who has hatched up the conspiracy behind the entire operation.
All petitioner is in custody for 4 months. It is contended. Co-accused are on bail. He prays for bail. And a lawyer for the state submit petitioner is a habitual offender. He has criminal antecedents. We have considered the materials on record. Co-accused are on bail. There is no direct evidence connecting the petitioner with the crime. Under such circumstances, we are inclined to grant bail subject to conditions. Meet officer in charge.
Not to enter
So he is in custody. He is facing trial in a NDPS.
Oh. So what? 10,000 issues.
Deeply.
Next.
29, I beg to appear on behalf of the petition. The service upon the victim girl is incomplete. It is showing insufficient address. The allegation is
for evidence of the victim.
Lordship, kindly see.
Lordship, after evidence of the victim.
There are discrepancies, with regard to the version of the victim girl under 161 and 164. And there are discrepancies, of the mother of the victim girl under 164. There is no specific date of incidents, mentioned in the complaint. Although, the victim girl during her 161 has stated that twice she was raped, in the month of June. But, the mother of the victim girl is stating that August onward, she went to, the private tutor's, house.
Don't pay, let the victim be examined.
Yes.
Let the victim be examined.
And Lordship kindly peruses, the injury report for once.
Let the victim be examined.
Current case.
Victim petitioner prays for bail. He contends there are discrepancies in the statement of the victim and her mother. Data bole petitioner submit he accordingly prays for bail and a lawyer for the state submit. Victim is yet to be examined. Under such circumstances, petitioner prays not to press the bail application till the examination of the victim. Trial court shall ensure examination of the victim at the earliest.
The affidavit of service may be kept. Grateful.
My lord, I am for the petition. And at same footing, co-accused prayer was rejected. My lord, only one thing, if your lordship kindly directs the trial to be
They
expedited.
have considered the materials on record. Bail prayer of co-accused was rejected on merits in October 2023.
No. On 20th December 2023, page 8.
On 20th December 2023. Medical papers show disclose a case of rape. Medical officer is yet to be examined. Under such circumstances, we are not inclined to grant bail.
My lord, the trial be expedited. My lord, only 3 witnesses examined out of 39. As well. Grateful to you.
Make pleasure. This petitioner is in custody for 50 days. The incident took place on 21st of November 2023 in the evening. The complainant's brother was seated outside his home or residence. 3 unknown persons appeared there riding on motorbikes. They fired shot.
He sustained injury. He was taken to Apollo Clinical Hospital where he was declared broad dead. In the complaint, the only description about the miscreants is the apparels owned by them. But it is also alleged that some of the local people, local persons, they could identify the miscreants. Now, but in course of investigation, a person by the name of Pankaj Singh was arrested. At the time of arrest, he named 6 persons to be his associates. The petitioner was not named. Later on, Lord, the Pankaj Singh, while he was in custody, it is alleged that he has stated that under the direction of the petitioner, he and other associates had murdered the victim. This is the long and short of the story. And another law, the evidence that is alleged to have been collected against the petitioner is the telephonic conversation between petitioner and Pankaj Singh in the month of March 2023. Now, the contents of the conversation nobody knows. But this is the long and short of the story as far as the petitioner is concerned. Now, the petitioner was summoned under 160 CRPC in connection with a pending case. He attended the office of the Detective Department, Baranagar, on 21st of December, and he was taken into custody in connection with this case. But this is the long and short of the story. And there are other cases against the petitioner, but he is on bail in all those cases. And nothing has been seized from the custody of the petitioner. Nothing whatsoever. The only evidence collected is the statement of the co-accused. That too not at the time of arrest, but during the custody of Pankaj Singh after arrest.
Well, I will kindly first come to page 9, paragraph 13 of the of the petition. He is on bail, but your lordship will find.
We have seen that we have seen 30 cases.
No. Pankaj is a wanted person of the locality.
Your investigation is over or is going on?
Almost over.
Almost
over. Materials have been collected.
Now, can you indicate to us what is the material implicating the petitioner?
Lordship. My lord will kindly come to page 406.
In the second part.
This is the mobile details of the
CDRs.
Phone details of the 406. Yes, those papers.
Can you see
the first page your lordship sees, it is of the petitioner.
Can you see the date?
Now, yes.
The month.
Yes. Now you're
finished.
I'm sorry, but I'm tendering apology.
Then my lord kindly comes to 417. My lord sees the those small papers, my lord. This is the highlighted portion. Your lordship will kindly see the tower location. The petitioner was in Kaksha. Now your lordship kindly comes to 423. These small pages only. This is of Pankaj Singh. This is the phone numbers and all in the top. Now 424, your lordship will find both of them were at Kaksha on that particular point of time.
Correct. So,
what has transpired is, my lord,
is he not a resident of that area? He is not a resident.
No.
This is Jagodal police.
My lord, Bhiki Singh, the victim, owing to be coming down from Bihar, had a tremendous control in ward numbers 16, 17 and 18 of Bhatpara municipality. My lord, Bhiki Singh was close to one Saurabh Singh, who happens to be a nephew of a political leader in that area. My lord, this petitioner before your lordship is very close to that political leader of that area. Both had shifted their allegiance to from a particular political party to another political party.
This Vicky and
No,
petitioner.
the main political leader and one Saurabh Singh, his nephew, both had shifted to BJP. Saurabh Singh was given a ticket to contest in the municipality. He won the municipality ticket, but he again came back to his parent political post. The Vicky, who has a tremendous control in ward number 16, 17 and 18, was supporting Saurabh. And as Saurabh had come back against the wishes of his father, the uncle was very angry. The petitioner before your lordship is a close associate of the uncle. Now your lordship will kindly come to page 381. He is the nephew of the 164 statement of the nephew. 381, your lordship. First one. The other one. He was being continuously threatened by this petitioner for his supporting Saurabh Singh. My lord, these witnesses did not come forward at the initial stage also because of the threat he has over the, or his control over the area. My lord will now kindly come to 382, the wife of the deceased. Same your lordship will get at 539, 543, 545.
জানি না দেখতে পারো
He was being continuously threatened and told if you don't leave the company of Saurabh, you will be done to death. Now, না একজন অ্যাসেলেন্টের নামটা জিজ্ঞেস করো তো মুসলমান কেন না
Tricks were hard.
Yes, my lord. The petitioner before your lordship had met Pankaj. Pankaj has arranged Iftikhar, Bangali and Suraj. Iftikhar is arrested, Bangali and Suraj are absconder. It has been found from the CCTV. They were the main assailant. A juvenile was arrested also. Mr. Rais Ali.
So the arrest is of one Pankaj.
Pankaj is the main man who had done the entire hiring of shooters.
Was he amongst the three persons who?
No. The shooters are Iftikhar, Bangali and Suraj. Pankaj, they were, one of them were local, but identification, showing the road, these were all done by Muhammad Rais Ali and Ankit Kumar Singh. Rais Ali is a juvenile, and the logistic support, your lordship says, although this is not the correct word, was given by one Imran.
So these persons have been arrested.
My lord, Rais has been bailed because of being juvenile.
Achha.
Ankit is in custody. Pankaj is in custody. Two of the shooters are yet to be arrested. One is Bangali and another is Suraj.
And who has been arrested of the shooters?
Iftika. I'm not taking your lordship's to the co-accused statement.
Oh, that's okay.
We are on the verge of completion of investigation. Perhaps over this weekend, the charge sheet will be drawn.
543, 545.
Lordship. Yes. 543 and 545, your lordship will find that the petitioner threatened the deceased in their presence.
That is what we are saying. This is the direct evidence of threat being held. The other 164 statements that you are saying, they are hard.
Yes.
The threat, and they are saying that.
Saurabh says he has heard. The nephew of the main political leader.
Yes, that he has heard about.
He has heard.
And he says that there were messages sent to him by another boy. Now, you have not collected any trail.
No.
Any
Honor,
message.
I cannot tell before your lordships, the mobile phones which when he was arrested and produced, the mobile phones were taken away by fellow members of the bar.
Fellow members of the bar?
Our fellow my brothers in the trial court.
How?
I do not know.
No.
We couldn't get hold. We couldn't get hold of the.
Stabilizing investigation.
We could not get hold of the mobile phone of the petitioner before your lordship. Any.
Otherwise, we would have asked you about the lat long report with regard to presence. From the
No.
Yes, Mr. Basu, we know what happens in police offices also.
No. This was not taken away by the fellow members of the bar.
Naturally.
This is written in the forwarding report, something else. That's what I was going to.
Forwarding
report? Yes. Written during investigation of this case, it came to learn that on 21st December 2023, at the time of arrest, accused person Smith handed over his two personal mobile phones in his associate to his associates who came with him at the DD office. That's all. I handed over the phones to my associates and then entered the office. With phone, I cannot enter the office of the director department.
Who are the associates who came to the office along with you?
Well, do we have the Langlong? We will take care of the.
Place the lat long report. Lat long report will show the access between these persons. Petitioner contends there is no direct evidence connecting him with the murder. He has been falsely implicated in the case. One Vicky Singh was gunned down by 3 unknown miscreants. First information report merely discloses the wearing apparels and other feature and bodily features of the miscreants. It is not the prosecution case that he was one of the miscreants. One of the miscreants who fired at the victim. Prosecution, senior counsel appearing for the petitioner contends. Prosecution has sought to implicate him as a conspirator. Materials collected in the course of investigation, that is CDRs and other statements, are vague and non-specific in nature.
The month of March.
Vague and non-specific in nature. They relate to conversations between petitioner and co-accused Prakash Singh. Pankaj Singh, made in the month of March 2023.
2023.
while
And
the
incident
offense
took place in November.
in November 2023. There is, accordingly, he prays for bail. Learned public prosecutor opposes the bail prayer. He contends one Vicky Singh was a close associate of Saurabh Singh. Saurabh Singh, right?
Yes. Saurabh Singh.
Saurabh Singh, nephew of a prominent political leader in the locality. Vicky was a member of, he was an elected representative.
No, Saurabh was an elected member of the.
Vicky had influence in some of the wards of the municipality. Both of them had shifted allegiance, their political allegiance, which angered the petitioner, another associate of the aforesaid political leader. Would stop. He held out continuous threats to Vicky. He held out threats to Vicky that he would be murdered. Full stop. CDRs show petitioner was present at the place of near the place of occurrence, and also had telephonic conversations with co-accused Prakash Singh. Full stop. He has criminal antecedents and investigation is still in progress. Would stop. We have considered the materials on record in the light of the learned lawyer for the victim. You're for victim.
For the de facto complainant.
Learned lawyer for the de facto complainant also opposes the bail prayer. We have considered the materials on record in the light of the submissions made at the bar. One Vicky Singh was a local councillor. He was associated with,
Saurabh was the local councillor.
Vicky
was associated with Saurabh.
Vicky was associated. Vicky Singh, a friend of Saurabh Singh, one Vicky Singh was murdered by 3 unknown assailants who came in a motorcycle. First information report discloses the wearing apparels of the miscreants as well as their build. Full stop. As well as their build. Full stop. In course of investigation, it transpired the said Vicky Singh was a close associate of one Saurabh Singh, a local councillor and a relation of a political leader of the locality. Full stop. It is the prosecution case. Saurabh and Vicky had shifted their political allegiance. This had angered the petitioner, who is another associate of the said political leader. Full stop. Motive of the crime appears to be the internecine battle between internecine turf war between Saurabh Singh and Vicky on the one hand, and the petitioner and his associates on the other hand. Full stop. Petitioner and his associates on the other hand. Statements of witnesses recorded under 164 CRPC at page 381 and 382 of the case diary, and under section 161 CRPC. Statement of Saurabh Singh and wife of Vicky recorded under 164 CRPC at page 381 and 382 82 of the case diary show Vicky had received threats. Vicky had received murder threats from the petitioner. Full stop. Other witnesses also corroborated such fact, and stated that petitioner and his associates had threatened Vicky in their presence. Their statements are recorded at 539 and 543 of the case diary.
539, 543, 545.
And 545 of the case diary. Full stop. Conspiracy, this proves, these materials prima facie show inimical relationship between the petitioner and the deceased and provides motive for the crime. On the charge of conspiracy, prosecution has collected CDRs which show telephonic conversations between co-accused Prakash Singh, who Pankaj Singh, Pankaj Singh, who appears to be a prime player in hiring the miscreants, in hiring the sharpshooters who had fired at the victim. One of the sharpshooters have been arrested, while others are absconding. It is strenuously argued that CDRs show a telephonic conversation between CDRs show telephonic conversation between Prakash Singh and show telephonic conversation between. It is strenuously argued that the telephonic conversation between petitioner and Prakash Singh is of March 2023, while the incident occurred in November 2023. Full stop. Lapse of time between the. However, it is undeniable that petitioner had inimical relationship with the deceased and had threatened to murder him. He was in contact with another prime conspirator, namely Pankaj Singh. Full stop. Investigation in the Pankaj Singh. He is an influential person with criminal records, full stop. Investigation is still in progress, and two of the sharpshooters are still at large. In the light of the aforesaid discussion, we are of the opinion there are prima facie materials disclosing motive and involvement of the petitioner in the conspiracy to murder the victim. Full stop. His release on bail at this stage would adversely affect the course of investigation and also impact the arrest of adversely affect the course of investigation. Full stop. Accordingly, we are not inclined to grant bail to him at this stage.
Prakash will be Pankaj and Vicky Singh will be Vicky Jadhav.
Vicky Jadhav and Prakash will be Pankaj.
Not this week.
Industrial.
Mr. Shopon Kumar Mollik is for the petitioner lordship. Due to his viral fever, he could not come to court. I am praying for not this week.
Yes, Mr. A. Yes. So we keep it Monday or Tuesday?
Tuesday.
Tuesday, my lord, Tuesday, time.
Yes.
Well, kindly make it Monday, my lord.
Monday.
Yes, my lord.
Monday.
Grateful lordship.
We were thinking if it doesn't recover. Any difficulty, any date before the trial court or something?
No, my lord.
Then we can keep on Tuesday. Let him recover and come. Suffering from fever.
Yes, my lord. Tuesday.
Are both of you are comfortable on Tuesday? Next.
May please, my lord, this is my affidavit of service, my lord. My lord, in the month of my lord July, my prayer was turned down by this honorable court. After the rejection of my lord's the prayer for the bail of this petitioner, my lord, 5 occasions, my lord, took place for recording of the evidence. My lord, 11th next month is the fixed for the date. My lord, kindly direct on that day to my lord, produce the my lord the victim for the examination, and my lord posted this matter, my lord, after 11th, my lord.
Why people have to come for a bail application for you to produce a victim, Mr. A?
They may have come after 11, lordship.
They have waited for 5 dates, he is saying. Petitioner submits. He is in custody for
1 year.
1 year and victim has not yet been examined. Learned lawyer for the state contents. Hence he prays for bail. Learned lawyer for the state contents. Date has been fixed for examination of the
On
victim.
11th of September, March, my lord.
11th of March 2020.
11th of
We request the trial court to ensure examination of the victim on that day positively. If the court is unable to do so, positive now on that day, and if the court is unable to do so within 7 days positive, by 18th of March 2024 positively. Let the matter appear on 20th of March 2024. Victim officer in charge shall notify the victim with regard to the pendency of the proceeding.
My lord, liberty to file a supplementary affidavit. I will annex the my lord further development. I will.
Our officer in charge.
Next.
I need to, I'm praying for leave to amend the cost study. It will be CBI.
Taken over by CBI.
Will be CBI.
CBI.
Yes,
Liberty to add CBI as a
And
party.
your lordship has another accused person in CRM number 4533. Your lordship fixed the matter on
to
15.
CBI through the office of the additional solicitor general. Matter will appear
on 15th with since your lordship has seen February.
On 15th February.
It is a holiday, na?
Along with Swans.
15th is a holiday, but your lordship has passed the দেখো
16. Along with this will come on 16.
ঠিক আছে আলাদা করে দরকার নেই তুই অ্যামেন্ডটা করে অবলাইজ না
আচ্ছা হ্যাঁ ঠিক
Yes.
My lord,
I am renewing my prayer for bail. My lord, the incident occurred, it was the day of Diwali. This petitioner is the son-in-law of one of the accused. My lord, he visited the matrimonial home with his wife on that day. And my lord, the dispute cropped up between two neighbors over bursting of crackers. My lord, his complicity is under section 34. And as on today, my lord, more than 2 years he is in custody. Charge is already framed.
Co-accused were absconding, so charge was not being able to frame, but now charge has been framed.
6 persons are on bail.
Minor date has been fixed for the evidence. This month, 23rd month.
My lord, more than 2 years. 2 years, 2 months.
Petitioner is in custody for 2 years and 2 months. He submits there is delay in trial. He renews his bail prayer. Learned lawyer for the state contends delay was due to abscondence of co-accused. Presently, date has been fixed for recording of evidence. We have considered the materials on record. Bail prayer of the petitioner was rejected earlier on merits. Full stop. Delay in the matter was due to abscondence of co-accused. Thereafter, the co-accused have been arrested and charge has been framed. Date has been fixed for recording evidence on
23rd of February 2024.
23rd of February 24. Offences, even if proved, would attract mandatory life imprisonment. Under such circumstances, we are not inclined to grant bail at this time.
He's a son-in-law, my lord, on that.
Son-in-law, though, you go and beat up son-in-law, kill him, then what can be done? If son-in-law killed your daughter, what would have happened?
Great.
Well, I am for the petition. I am 29, victim was 30 years. Both are fled away, took a rented house. I am custody about 90 days. Victim and petitioner.
Then who was watching them? Where is him?
I am 29, she is 30. It's a married lady.
You took a picture.
I taken into PC, but there nothing has been recovered. My lord, and my lord, she has been medical also refused, my lord.
Medical refused, that's a different issue. My lord, pictures taken, my lord, she used to bath in the pond.
Have been collected during investigation.
My lord, the mobile phone by which it could not be, in spite of repeated visit to the spot, accused.
How long are he in custody?
96 days.
Petitioner is in custody for 96 days. Investigation is complete. No objectionable pictures were recovered from the petitioner. Investigation is complete. He prays for bail. And a lawyer for the state opposes the bail prayer. He submits petitioner and took objectionable pictures of the victim. We have considered the materials on record. No objectionable pictures of the victim was collected during investigation. Charge sheet is complete. There is no chance of abscondence. Accordingly, we are inclined to grant bail.
Client served and they received, my lord.
Very good. Service is placed on record. Next. CPM question.
I am for the petition. This is the affidavit of service. It has benefited, yes. When I am renewing my prayer for bail, if your lordship kindly turns to page 41 and also your lordship's order. Your lordship will find your lordship's specific direction where by this honorable bench, my lord. Page 16.
Yes.
But not a single witness has turned up. They are not interested to come to the
charge has been
whether this order has been over. But order has been communicated framed. Yes, long back.
Where is the
whether
order sheet?
this order has been communicated to the trial court or not, my lord, that is not my lord, known my lord. Because thereafter, my lord, I seen my lord from the two schedules. My lord, never, my lord, it has been reflected that this order has been communicated to the trial.
Whose duty is to lead evidence and convict a man? Whose duty? Accused. That he will bring evidence against him and get convicted. Judge. Whose duty? That you come up with all these statements, order has not been communicated. Who was appearing in this case? Only the petitioner was appearing.
No,
State was appearing. State does not have any responsibility. Huh?
It has also the responsibility.
Then? When is the next date?
Next date, my lord,
27th of February.
27th of February.
Again, we want the victim to be positively examined during that.
This
is the fourth schedule. Petitioner renews his bail prayer. He contains petitioner contends in spite of number of schedules being fixed, prosecution witness has not been examined. He renews his bail prayer. We are from the order sheet annexed to the petition, we note the next schedule is fixed between 27 February 24 to 29 February 24. We direct the trial court to examine the victim and her relations positively during the said schedule. Report shall be filed before this court on the adjourned date, 5th of March.
As a
Parties shall cooperate with the trial court and communicate this order. Next.
My lord, 4 and 6 of the POXO Act, 155 days in custody, 161 as well as 164 statement of the victim says that she was having a relationship with me. Her parent. Yes.
Victim notified.
No, my lord.
Let we notify the victim.
Lord, we have also, my lord.
Right. Officer in charge shall notify the victim with regard to pendency of the proceeding and next date of hearing. Matter will appear 2 weeks hence.
2 weeks.
Management.
Please, my lord. What are 3? Sorry.
Pulta hoga sir.
Please, my lord. What are 395, 397?
Dacoity.
My lord, I mean,
And now you
custody
are
over 1 year, my lord, 10 months.
Only. Only.
Now, my lord, what happened, my lord? Co-accused person, my lord, the allegation against the petitioner, my lord, is that he was with one of the co-accused persons, my lord, in a hotel.
Only.
And that was, my lord, on 28th of December 2021, and the occurrence was on 8th of January 2022. But there is no other evidence. The main accused person
is the gang operating in different states. All right.
My lord.
Your friends and yourself have criminal cases across country.
I'm on bail.
You are he is one of your best clients. All India practice. All right. Jharkhand, Bihar, Bengal, Odisha. 4.
Well, I was in honeymoon, my lord.
You are leader of Eastern Region Dacoity Association.
Well, that's the Oman Sahu, my lord, who is the prime accused, my lord. No, my lord, I was in honeymoon, my lord.
Honeymoon?
No, my lord, I was in honeymoon. I have a friend of mine, my lord, Mohit, who was also arrested with me, my lord, from Goa. No, my lord, he was discharged in the charge sheet. Now, my lord, kindly have page 16 once, my lord. Who accused was granted well, 1 person, my lord, by your lordships, because there is no incriminating material against that person. My lord, I am on same footing, my lord. Rather, my lord, that gentleman used to meet Aman Shahu in jail.
Anything against him?
The person came in Calcutta, 27th of December. He got in a hotel. Thereafter, on 28th, he, along with other 3, conducted a reconnaissance in the place of occurrence. So that is the test identification for parade by the person from whom they searched about the house and the locality and they took photograph of that particular target house. Thereafter, that was handed over to another group of people. They came and conducted, my lord, that dacoity in the house. The role of the petitioner is the conspiracy is that there, my lord. The role of the petitioner, he came earlier along with other things.
Right.
Conducted reconnaissance, took photograph,
Right.
and gave information. Accordingly, dacoity was found.
And now he is in custody for 1 year, 10 months. What is your stage of procedure?
No witness was examined. And my apologies. My apologies. My apologies. I'm so sorry. My apologies.
You are a busy, your co-accused is a busy man.
No. My
He is keeping 5 trial judges busy. Everyone wants him because their trial is being stalled. Entire country, everyone, because you put him in Odisha, the Jharkhand cases are stalled, Bengal cases are stalled. We directed nodal officer of Jharkhand to so that he can be produced.
But that was your lordship's order, my lord.
Thereafter, what has happened? We want
22nd March, a schedule has been fixed for recording of evidence of the patient.
of the victim. And all the accused are now in Calcutta, or you are getting access online?
They are getting access online. That's reflected in the order, my lord. That's why I'm assisting.
Correction of in another state already on the production warrant and will.
Not production warrant.
Virtual.
Yes, virtually you do it. Production warrant, it will, he will get bail.
Yes.
Now he challenge this order in Supreme Court.
Well, let them challenge, my lord.
No, they will not. They will not. You
So let this order go unchallenged, my lord.
State does not have money. You have power, muscle power, money power.
No, my lord, I don't have, my lord.
Supreme
Court. Oman
and you say that how can trial take place without compliance of 267 CRPC? Okay. Good point. Notice 267 CRPC. Should it be subservient to 272 CRPC? Then, so that is a good point. We'll observe that.
Personal appearance.
Personal appearance. Whether personal appearance under 272 should be interpreted in a manner which renders provisions of the code odious. So, arguable point.
Petitioner, kindly have the last page of the page. Kindly have the last page, my lord.
We have had first to last page.
Now, are your lordships with me, my lord?
Let us see.
But kindly have the last page once, my lord. There's a reason, my lord. Sees third last paragraph. Sees, my lord, why trial was held back, my lord. Sees this, my lord. My lord, may I just read it out? It is to be mentioned that there is no sincere cooperation from the side of the learned special public prosecutor to proceed with the case with the trial. So the learned special PP must remain present to assist the court on the next day, such and such. But prior to that page, my lord, the entire page is against, my lord, the public prosecutor that he didn't turn up. It's not that, my lord, on account of the reason that the accused are located at different jails, my lord, the trial is held back. The entire page, my lord, the second page, my lord, narrates how the trial was delayed by the public prosecutor.
Petitioner is in custody for 1 year, 10 months. He submit. He is no way involved with the dacoity. He was not present at the time of dacoity and no incriminating articles were recovered from him. Trial has been delayed due to the absence of the special public prosecutor. Accordingly, he prays for bail. Learned lawyer for the state contends petitioner is member of a gang of dacoits, some of whom are gang of dacoits. Some of them have some of them are implicated in cases in different states. Full stop. He had met the principal offender in a hotel in Kolkata. Thereafter, he conducted reconnaissance of the house where dacoity was to be conducted. Local witnesses, he had interviewed local people. These local people identified the petitioner and disclosed his role in the dacoity, in the conspiracy to commit dacoity. Date for recording prosecution evidence is fixed from 12th of March, 22nd of March 2024. We have considered the materials on record petitioner is a member of a gang of dacoits operating in different states. Most of its members, some of its members have cases pending in different states, and this court had to intervene in the matter in different states. Initially, this delayed due to their non-appearance. Proceedings were delayed, and this court had to intervene and observe that and direct that the attendance of the co-accused who are facing trial in other cases may be done via video linkage. Full stop. Thereafter, video linkage. Thereafter, the matter progressed. Charges were framed. Matter progressed, charges were framed, and date has been fixed for recording evidence. Full stop. Absence of special public prosecutor. In this backdrop, absence of special public prosecutor, though undesirable, cannot be held to be the sole ground for delay. Full stop. On merits, we note petitioner was actively involved in the conspiracy. He had conducted reconnaissance he had met the he had met the other members of the gang, conducted reconnaissance of the spot where dacoity was held. He does not stand on the same footing with co-accused so-and-so, whose bail prayer was allowed, as the materials collected during investigation against him were inadmissible in law. Full stop. Under such circumstances, there is every possibility that the petitioner may abscond if he is released on bail. Under such circumstances, when the case is delicately poised for recording prosecution evidence in the next month, we do not, in the month of March 2024, we do not consider it prudent to release the petitioner on bail. We direct the trial court as well as the prosecution to ensure that the witnesses are positively examined in the course of next schedule. No adjournment shall be given to any of the parties, and witnesses, if in attendance, shall not be turned away on the ground of resolution of the local bar. Full stop. Parties shall cooperate with the trial court and communicate this order. All right. Let us see next.
Orders, I mean, observations may not be prejudicial.
Will be binding at all stages of the procedure.
God bless.
Yes.
Lordship, this is
Yes.
appeal filed pursuant to a special leave granted by your lordships on the 25th of July, 2020.
Leave granted?
Yes, leave has been granted.
Leave was granted. We have perused the grounds of appeal. An arguable case in appeal has been made out. Now, leave has been granted to prefer appeal.
Yes.
Appeal has been preferred within time. Appeal is admitted, issue usual notices, call for records. So and so within fortnight shall appear before the trial court, and upon appearance shall be released. Paper books be prepared within 4 weeks.
Deeply.
Next.
Wait, please, Your Lordship. My lord, this is a delay of 97 days. My lord, let me serve and come back.
Accused?
No, my lord.
Acquittal.
Acquittal.
Copy. Appeal is barred by limitation. Copy of the application for A shall be served upon opposite party number 1 through public prosecutor, opposite party number 2 registered speed post 2 and 3 through registered speed post with acknowledgement due. File affidavit of service on the adjourned date, adjourned 6 weeks. Next.
May it please, Your Lordship. My lord, the conviction under section 448, 376 of the Indian Penal Code, my lord. Alleged date of incident, my lord, is 1st August 2017. And my lord, prior to that also, that is in the FIR, my lord. My lord, will find the evidence of the victim lady, my lord, suffers from, my lord, patent improbabilities, my lord.
he has given me like three different versions, my lord, at different stages. In FIR, my lord, she has said, my lord, that on 1/8/17 and earlier there too. My lord, before the doctor, my lord, PW11, my lord, she has said no story of, my lord, the alleged sexual assault. And my lord, the evidence of, my lord, in court along with the evidence of PW2, my lord, are, my lord, totally divergent. Your lordship will find, my lord, what she has stated before the doctor, my lord, the alleged history of physical assault. No story of, my lord, the sexual assault is there.
Where is the doctor's evidence?
My lord, can you say this is PW11, my lord, at the copy, my lord? Can you excuse me, my lord, I have the only one copy, my lord, I could not.
Why only one?
My lord,
Page 18.
এটা একটু দিয়ে দেবেন জোসেফ
এটা একটু লেবেন
এটা একটু একটু দেবেন এটা একটু
But he says nothing.
Internal page borrow. Internal page borrow. Borrow. Private plots, processing optimal did not disclose.
No, there is no cross-examination on that.
My lord, cross-examination, next page, my lord.
What?
My lord, VG did not disclose any incident of rape before me, my lord. That is at also, my lord, at page 12 of the judgment, my lord.
All right. Appellant, were you on bail?
My lord,
Appellant was on bail during trial and did not misuse his liberty. He contends that allegation of rape is an embellishment. Victim did not disclose the offense before the treating doctor PW11. He prays for suspension of sentence. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Victim alleged that she was raped at her residence. Victim alleged that she was raped on 1/8/2017 at her residence. No one was present in the house. Good stop. However, she was medically treated before PW11. The said witness during cross-examination stated that she did not complain of rape. Full stop. No bodily injuries were also noted on the victim. Now, although victim alleged that she had been forcibly raped, no bodily injury were noted. Full stop. Sentence is one of term imprisonment, and there is no possibility of the appeal being heard out in near future. No aggravating circumstance against the appellant is placed on record. In view of the aforesaid and the law declared in Gosen, we are inclined to suspend.
CGM.
Overstate. Next.
My lord, I am for the appellant. I'm representing appellant numbers 2 and 3.
I'm representing appellant number 1, my lord.
44, my lord, I am for the another appellant, my lord.
My lord, this is the affidavit of service we have notified, but it has come back
Same.
with the endorsement
my lord.
insufficient address.
Insufficient address.
Same, my lord. For the victim.
এটা দিন তো
6.
My lord, 6 and 376D.
Then
My lord, the principal accused is absconding, my lord.
6.
maybe
The appellants were all on bail during trial. Is in custody since November 2022. Now, if your lordship kindly.
that is the evidence of the victim.
Yes, ma'am.
Yes, 40, মানে
But
item
along
number
with
44.
44, it has been annexed, ma'am.
Everything.
Right, 44.
Who is the father?
Let us see PW1.
W1 case 25.
স্যার আপনি এদিকে চলে আসুন না
Over to you now.
to the pendency officer in charge with the pendency of proceeding and next date of hearing.
My lord, in both the cases, a charge sheet has been submitted, my lord.
Mr. Counsel, these conditions were imposed on the de facto complainant praying for your cancellation of bail. So if we are to waive the condition, we must hear them.
Report be kept.
Yes, report is kept on record. Next. 2 weeks, 2 weeks.
This is, my lord, for an appropriate order, my lord, or on modification of the condition of bail. Yes,
Who is oh, Mr. Yes, what do you say? What is the condition of bail?
No, at page 11, my lord will find.
The limits of the district.
Yes, so what do you say?
I have to take it.
Take instruction.
My lord, only on, I'm telling you, 1 minute.
Let him
My lord,
take
this is-
instruction.
Yes, no, he will take, my lord. Only,
Then we don't want to hear you any further. Adjourn 2 weeks.
no, my lord,
Report be filed.
15th of February, there is a medical emergency, my lord, an appointment has been taken. That's, my lord, Hyderabad Asian Institute of Gastroenterology. That is the reason, my lord, I was.
Why you are coming today?
His wife will go.
Why are you coming today? Monday. Take instructions by Monday. All right.
I'm obliged.
Next.
'56, my lord, this is a application for relaxation of the condition of bail. Bail was granted on 12th of August 2021.
Application is dismissed. Liberty. Paper books ready? Application is dismissed. Appeal is ready for hearing. Application is dismissed. Liberty to pray for early hearing. Next.
Yes, my lord, I am appearing, my lord, for NCB. My lord, report, my lord, they have complied. Paragraph 7. Can you just check for me?
Report is placed on record. Petitioner has complied with the conditions of bail. Accordingly, what is the condition?
To meet the investigating officer once in a week and shall remain within the jurisdiction of Ulupuria Police Station. Page number 10 will.
Yeah.
Page number 10, the second paragraph.
Conditions of bail to remain within jurisdiction of Uluberia Police Station and to report to the officer in charge of the said police station once in a week are waived. He shall report to officer in charge Uluberia Police Station as and when necessary. Other conditions of bail shall continue. Next.
Lordship had called for a report, my lord, as regards my compliance.
Report be filed on the adjourned date, adjourned 1 week. Next.
But the state has preferred this
2 weeks.
Well, the state has preferred this application for cancellation. Now the de facto has also filed, my lord, that is
List along with so and so.
1st of March.
List along with so and so on 1st of March.
And in the meantime, my lord, may I serve?
Yes. Next.
Your Lordship, I am for the victim lady. The accused was arrested and he has granted on bail. But my main concern is that my client told me that there is a videography of a sexual relationship between my client.
So what? Is it relationship between the two parties?
Your Lordship, the video is still on the position of the accused person and repeatedly.
How many days after detention he was released?
Only for 3 days, Your Lordship.
Only for 3 days.
Only for 3 days.
All right. Learned lawyer for the petitioner contends incriminating videography had not been recovered, but the opposite.
But I am for the opposite party number 2 in this matter.
Party number 2 has been released on bail. Copy of the petition be served upon opposite party number 1, state through public prosecutor. Opposite party number 2 has entered appearance. Matter will appear 4 weeks hence. Case diary be produced on the adjourned date.
Remember, I shall contravene by affidavit in opposition by the liberty.
Much obliged.
I'll come back at this. I'll come.
Yes, sir. Yes, sir.
Much obliged, Your Lordship.
My lord, your lordship will take 2 p.m. My lord will take up the Ponzi matters at 2 p.m. My lord. No, I am not
2:30.
2:30. Very good.
All right.
Okay. Very good.
Fix this matter on another day and then take it up, right?
2:30.
সুবিধা এখন তোমাদের অনলাইনে
Yes. Today, we have got the Ponzi cases fixed for Thursday. So we'll take the Ponzi cases, give priority, but you can argue for some time, then we'll fix it.
But the prosecution case, but if your lordship kindly glance through the first information report, your lordship will find that the father lodged the FIR. Well, the first information report, tribe is, my lord, the petitioner, the appellant. Appellant, my lord, being the maternal, what is called, my lord, the young maternal mama. My lord, the case is this, my lord, that on the date of incident, that is, my lord, 22nd February 1983, at about 3:30 p.m., the mother of the deceased, along with the grandmother of the deceased, left the house, leaving two daughters at the residence. And after some time, and my lord, there was a maidservant. He was, my lord, asked by the mother that when you complete your daily household work, you bring some snacks and give it to the daughter. Maidservant, my lord, left the premises residence, my lord, at about 4 o'clock. And my lord, thereafter purchased some snacks and gave it, my lord. The system is, my lord, that a rope with basket is being thrown, my lord, and there they keep the articles and lift it. My lord, entrance and exit door is one. Residence, my lord, the building is incomplete. They used to reside at the 3rd floor, and remaining portion, my lord, was meant for construction of a cinema hall. Now, my lord, at about 5:30 p.m., the younger daughter called the father over phone. Father is a businessman. He left the premises to attend his place of business and said that the deceased was not found in the residence. Then father asked her, younger daughter, that to see where is the key of the premises. He said the key is at the place where it should be. Then father came about, my lord, returned back to the home at about 6:30 p.m. and opened the padlock of the entrance door by his own key and went up. First, he came to his own residence on the 3rd floor. He could not find the daughter, elder daughter. Then he came to the 2nd floor. There in the veranda, he found something is lying on the floor. He put on the light and found, my lord, that his daughter is lying there, and there was, my lord, the smell of burnt kerosene oil. He immediately called, my lord, the other relations, mother also. Relations, also the appellant. What call came, and my lord, police was informed. Immediately, police arrived at the place of occurrence, and my lord, inquest was held, and some articles were seized, and a FIR was recorded, and case was started. This is, my lord, the summary of the process.
The case, FIR.
My lord, FIR, if you lordship kindly look at page 2. This evening at 7 o'clock, getting a phone call from my daughter Tuki when I returned at my residential home at third floor of my under construction cinema hall from my shop at Rastala. Then I saw that the entrance door at the staircase of the third floor is closed by a ghoul set. I myself opened that, and upon entering, I saw my daughter Tuki. Seeing me, Tuki asked, "Where is Didi?" Seeing the doorway to the third floor at the staircase closed, and knowing that my elder daughter is not at home, I rushed downstairs. And after taking a torch and coming to the balcony at second floor, I saw that my elder daughter Suroma, whose nickname is Nylon, is lying hubbund facing upwards, and the tongue is stuck out, and all her apparel is burned. Seeing nothing more, I ran upstairs and called my brother-in-law, Joymalya, over phone. That's the appellant. Joymalya reached within 5-7 minutes after getting my call and informed the police station over phone. Reached within some time. My wife and my mother-in-law went to the house of my younger sister at Shippur Lane. After some time, they too returned and saw the incident. The tongue of my daughter has come out in such a way that someone has strangulated her. That is why her tongue has come out and stool has passed through her rectum and set fire on her and her clothes. I saw further that on the third floor in the room towards east, where she usually studied, there her clothes, shorts, and petticoat, etc., is scattered around. My daughter was a candidate of MA examination through private. Her examination was to be held from 24th February. My mental condition being not well, I put my signature after my brother-in-law wrote this letter as per my statement. So, sir, please, this is the first information report. My lord, if your lordship kindly look at, my lord, the inquest report. That is at page 4. My lord, got it? Description, serial number 3, description of crops and position in which found. On the floor of the balcony on the second floor of the proposed mini cinema hall, the crops has been found head towards northeast, facing upwards. The legs of the deceased are towards southwest direction. From the hairs on head to the bills of both legs are burned. Must kindly take a note of it. From the hairs on head to the bills of both the legs are burned. The hairs on the head are braided neatly. Hairs are burned and tip of the braided hairs has been burned. And the broken pieces of burned hairs has fallen on the ground. Both the eyebrows are burned and eyes are closed. On the nose, there is blood stained. Mouth is open and the tongue has come out and blocked the opening. Tongue has come out about 1 inch, and on the tip of the tongue, there are biting marks. On both the ears, there are rings. It appears from the shoulder area of both hands that the blouse on the apparel was red color and blouse on the breast portion is burned and turned black. The sari on the apparel is burned to ashes and turned black. Yet from some portion of the sari near the hips, it appears that sari was a dot printed red one. It appears that a red petticoat was on the apparel because some portion near the right knee proves that the petticoat was of red color. Both hands are raised towards the breast and the fists are half open. The brazier is burned. It seems to be of white color. The area near the breast has become uncovered, being burned. From the navel area under the belly to both the legs are uncovered. Only on the right knee there is some portion of the red petticoat attached to the bottom portion, and the female organ is bare. Due to being faced upwards, the knees of both the legs are folded and are at a distance of 1.5 inch from one another. The pubic hairs are burned and the legs being apart, the genital opening and burned reddish. Some amount of stool has passed through the rectum. All the skin of the body is burned, is full of blisters. But this is important. All the skin of the body is burned and is full of blisters. The thumb of the right foot and the finger have blisters. The heel of the left foot has blisters. Near the braided hairs of the deceased, there is a bottle of essence or essence oil on the body, of which written, "Just call me sheer genius." Some burnt foreign envelope written in English and cover of company on which written, "Product of Wimco Pen Company, Bombay." Thereafter, my lord, the list of wearing apparels. 2 pieces gold like earring, both hands. That the red blouse on the apparel. The blouse on the breast portion is burned to ashes and turned black. The braziers seem to be of white color. Some dot printed red portions, sari such and such, red petticoat. Circumstances give rise to suspicion. So, my lord, this is the inquest report. Unfortunately or fortunately, my lord, the postmortem report was not made exhibit. Postmortem doctor was deposed, but postmortem report was not exhibited.
Why? Was not available?
We do not know. Oh, postmortem report was supplied. And my lord, it is also in the paper book. But it was not exhibited. Along with the 207 papers, my lord, postmortem report was given. And doctor, while deposing, he said that I made a note, but that note was not produced also. But from the evidence of the father, your lordship will, my lord, postmortem report is wholly illegible. Kindly look at my lord, page 12.
It will be there
Yes.
in the records.
My lord, may I place the evidence of PW1?
You do it on another day.
Hmm.
19th February.
19th.
Afternoon.
19.
Yes, call.
But my application, my lord, I have served everyone, my lord. Only one thing, my lord, there is a single copy of the affidavit of service. My clerk is bringing the other second judge's copy, my lord. I'm
How-
very sorry.
You have been given so long, you cannot.
It has been served.
Is anyone having objection to the application?
My lord,
of this?
I have, my lord, an objection to both the applications. I'll just indicate what it is because I want to file a affidavit to put it on record, my lord. এটা কি তোর SEBI টা?
13.
Ah.
My lord, can number 38 is the application.
Yes, what is your objection?
Yes, my lord. Can number 38, if your lordship takes, SEBI has filed an application now for reduction of the price by 10% of the reserve price, which is at page 15. Lordship kindly takes, my lord, these four properties. Now, my lord, the first property, my lord, second property, I have no issues. That, my lord, the everything is
You
perfect.
bring a buyer at that price.
I don't need, my lord, I'll bring a buyer,
Bring
but
a
there is something more to it.
Bring a buyer.
I will try, definitely try.
Then if you try, then keep quiet.
But then my objections have to be recorded, my lord. But they are, my lord, selling at a price which is much below to give it to people, my lord, which, my lord, perhaps would be getting it at lower price.
Bring a buyer.
Let me file an affidavit.
We have heard, we are
But
recording.
this is on record before the honorable court, my lord. I want to rely on those documents only. Orders passed by my lords.
You rely on whatever.
But then, my lord, I need to file an affidavit.
File an affidavit.
But then, my lord, lordship hears me at least. Here's my submissions. My lord will kindly take the first item which is there, which is a property, my lord, at Lake Town. The properties which are there at page 15. Now, my lord, this is a property, my lord, brought in well furnished in 2012 for a price, my lord, of more than 6 crores. In 2012. Now, it is unheard that, my lord, in 2012, whatever be the price, that has reduced now. It cannot be, it appreciates. It cannot come down. Now, my lord, these are ploys which used to happen, my lord, in the company court, usually, my lord, to give away, my lord, at a price to people who are known and who are, my lord, behind the back.
Like your clients will do it.
Very well.
They will
My clients would have done it. I take it, but that's also nothing. That is nothing which will be stamped by the court.
We are giving you one opportunity to match the prices by the
But
next.
this is not the price. It should be higher.
Correct. You come with this price at least.
The circle price in 2012 is higher.
Again, we are telling you, come with this price at least. Come with a buyer.
Well, that cannot be a, my lord, that cannot be an
Can
issue.
be or cannot be, we will consider. We are asking you to do that. Then we will hear everything that you want to say.
My lord, I cannot, just because I cannot bring a buyer today,
Yes.
does not mean, my lord, it would be sold at a price which is not acceptable under the law.
Because the exercise has already been done.
No, it has not been done. There is no valuation done. Kindly takes the order of Justice Mukherjee. Kindly takes, my lord. It says, my lord, that the valuation report has to be given. Till date, no valuation report given.
We have taken the circle price.
Circle price, my lord, is much higher. These are, my lord, valuations of 2017 or 2018 to the 2014. We are today in 2024. The valuation, my lord, I am ready and willing to do one thing, my lord. Since my lord is saying buyer, my lord, I am ready and willing, my lord, to pay for the entire expenses. My lord, let it be valued today by, my lord, any, my lord, Pricewaterhouse, Ernest Young or Talbot, my lord. I will bear the cost, even though I may not be able to, but I'll do whatever, I'll bear the cost. Let the valuation report come before my lord.
What will be the cost? Pay that money to the one-man committee to pay your depositors.
My lord, I don't know who are the depositors.
You don't have to know. One-man committee
But
knows.
today at 2000,
One-man committee knows. Please do not stand in the way of repayment to depositors.
I am not standing in the way to pay to the depositors, but my lord, the correct amount should come. Today, nobody knows after 12 years, my lord. Lordship's order says that ascertain what is the amount due and payable. After 12 years, with deepest of respect, after 12 years, no one knows what is the amount to be paid back to the depositors. Now, my lord, Lordship, let us take a situation like this. When we, my lord, go under section 7 of the CIRP or, my lord, section 9, my lord, there is a cutout date in which claims have to be filed before, my lord, or otherwise it is not taken. My lord, it is possible to believe that in 12 years, a committee could not ascertain what is, my lord, the cutout date or what is the amount to be paid to the depositors. So, my lord, these claims will run till eternity. Can that be possible, my lord? There has to be a cutout date that within which, my lord, the depositors, genuine depositors in terms of my lord's order, should file their claims.
They've already filed their claim.
It is not there. Till today, there it is not ascertained what is the amount due and payable to the depositors till for past 12 years.
If there is an clear picture,
yes, my lord,
persons who have approached the one-man committee and the outstanding claims so far as.
My lord, I have got that by my lord's order. I have got that. May I submit? 8,000 people. 8,000 people. 8,000 people, my lord, if I take it, the amount that has been given, my lord, comes to only 80 crores. 80 crores is the due.
Must you clear that 80 crores?
My lord, 31 crores is there by the submission. So, my lord, therefore, kindly have a valuation of this. If the valuation comes that these properties will suffice.
Where is 31?
My lord, this is in their affidavit.
It's
Just the page earlier, 31 crores, 92 lakhs, 4,147. That's what they've got. The amount of by sale of the properties.
By sale of the.
Yes. So this money came in, my lord.
The vendor of the properties, let it be sold.
Well, I am saying, let it be sold, but let the valuation be done. Let the valuation be done at my cost.
It has already been done.
But that has not been done. That valuation, my lord, is 2012. And my lord, the last property, which is at New Alipur, unbelievable, 8,606 square feet at New Alipur, sold for, my lord, being sold for, my lord, if I take the statutory dues also for 6.5 crores. I brought it for 10 crores, for 6 crores in 2012. My deed is there. 6 crores I have purchased in 2012. Sorry, 10 crores. How can that be, my lord, reduced to 6 crores in 2024? Gross below price it has been offered. My lord, the deed will speak for itself. Kindly have the deed before my lord. It's a property of more than 8,000 square feet in New Alipur. My lord, the CBI has filed, my lord, before my lords an affidavit where CBI has said it is worth 10 crores. How can it be sold in 6 crores? That's exactly what I'm saying. Let a valuation be done at my cost. I am not standing in the way, but let the correct picture come out. This is the affidavit filed before my lord by the CBI. I just want to put this on affidavit. Kindly takes my lord here.
Put it on affidavit.
Yes, I can put it on affidavit, my lord. Well, that I'll separately argue. My
Our claim
একটাই আছে ইনকাম
My lord, may I just indicate, my learned friend is wrong. He has a claim of 236 crores, not 136 crores. I correct him. I correct him.
That is not 160 crores. There are other companies that come to 200 crores.
Very well, my lord. 136 crores. Now, my lord, kindly sees, I have got a list. All these matters, whether his claim is maintainable or not, is pending before the income tax tribunal. My lord, just a minute, that has not been quantified.
He made an application for addition of party.
Yes.
Let the addition of party be allowed.
But I am saying that addition in party cannot be allowed. Dada, ekটু সরবেন. Cannot be allowed because of the simple reason that his claim has not been quantified, out of which 3 to 4 applications of his claim has already been rejected.
Done. After he's added as a party.
Yes.
And your response to his application that there is a charge on all your properties is adjudicated by us.
But there cannot be any charge, my lord. Why I'll tell my lord.
Exactly what we are saying, that there cannot be any charge. For us to record that, we need to add them as a party. So they are bound by our order.
No, my lord, then, my lord, kindly will put this that they are added. My lord, they have another application which is for their claim. My lord, that I'll file an affidavit. This may be added without prejudice to my rights and contentions. Because otherwise it would affect my proceedings there.
Addition without prejudice to rights and contentions, and you file your objection or
To the main application which he has filed. And this I'll file an objection, my lord.
and for you, you also need to file an opposition to their application.
So we are only soft copy.
Yes, because it depends. Please give a copy to the petitioner, SEBI and Mr. Banerjee's.
And there is one more thing, my lord, that application which is on a different point of law, where, my lord, at least, my lord, grants them time to file the affidavit, because that's, my lord, on a different issue, my lord. My lord, the 512, my lord, that, my lord, I have placed before, my lord, can be taken up, my lord. That's on a separate issue, nothing to do with this. Because one, my lord, this is with regard to the issue, my lord, whether, my lord, companies where, my lord, bank has finance, bank is running the company, that can be put in this hodgepodge. Now, my lord, I understand then, my lord, it was an order of that kind in those times, my lord, I understand. But today, my lord, if I can show, which is there on pen and paper, that the bank is the person, my lord, who has run it, then, my lord, that cannot be attached, my lord, as a depositor's amount. There's no depositor's amount involved. So that mat can be taken up on any day, my lord. And, my lord, let them file their affidavits. I'm not standing in the way. Let them at least file their affidavit.
The MAT application that
Appearing.
manager has filed, is it ready for hearing? All the
No, my lord, they have not filed affidavits.
559. So it is the original appeal. The original appeal is 512 and along with 559, all along it is appearing. Now my learned friend is raising this question. For last 2016, they have not raised. Not only that, your lordship is giving a liberty them to file an opposition to the SEBI's application. I'm just drawing your lordship attention to page number 92 on once. This particular offer, the decreasing of 10% was made in the year 2017. Since 2017, his client has not raised any issue.
whatever it may be,
Very well, Bernard. I'm not standing in the way.
let the affidavit be filed and placed before us. We will consider.
And so far as his application is concerned, 512, I will check Bernard because it is sub long time.
I will again serve him. Let him file his affidavit. I'll give a copy here and now.
You also see, so far as 512 is concerned, whether your interest is protected there, and file your affidavit on that. Your applications to the extent of addition of party is allowed, subject without prejudice to the rights and contentions of the petitioner and respondents.
And, my lord, is another application, we'll file affidavits soon. Great.
And Mr. Chakraborty make amendment adding him as a party. Oh, your application.
My lord,
Mr. Banerjee.
my lord,
So make necessary.
my lord, before my lord passes an order, my lord, kindly makes it a short, my lord, because
Yes,
otherwise
because
we
I'm
are
also
already
praying that, my lord,
with
because
this affidavit on this price reduction application.
2 weeks since.
2 weeks, my lord.
Within 2 weeks, file your affidavit.
I want that, my
We are
lord.
not keeping it because Thursday is a holiday. So we'll keep it Thursday week.
Thursday.
In
Great.
that, within that time, you are the only one who is opposing. So you file your
Absolutely.
affidavit.
I will, my lord. Definitely.
Okay, SEBI the application.
Can number
got the
30.
second judge's copy by now?
Yes, I have already handed over. The second affidavit of service copy.
এই তো রাখছে সবই তো পেয়ে গেলি তিনটে কি হলো তো
Can.
তিনটে
আছে তো? Can 3839 application has been filed on behalf of SEBI seeking reduction of price of reserve price for auction of certain properties. Affidavit to the affidavit opposition, if any, to the application be filed by the adjourned date. Matter will appear on 22nd. On 22nd it will appear.
No, 27.
22nd এর মধ্যে বলছি।
By 22nd you will file, matter will appear on 22nd.
Matter 27.
It will appear on 22nd, by 22nd you will file your affidavit.
22nd only, Lordship.
Or you,
My lord, I intend to file a reply also.
Okay.
Short. That
Then
will be
22nd, reply by 29th.
And matter will be on 29th.
No, we won't keep it on 29th.
Well, this has to be because the other matter where the interim injunction is there, that is still 29th.
4028.
That Lordship can keep
Well,
separately on 18th then, my lord.
Which one?
The one that is expiring on 29th.
18th of? 18th is a holiday.
Holiday.
My lord, I only need 2 days time, my lord. If my learned friend can do it by 20th, my lord can keep it on 22nd. I need only 2 days time because I think there won't be much apart from the valuation part.
So, everyone. So the affidavit in opposition, let it be filed by 20th. Reply, if any, by 22nd. Matter will appear on 22nd.
On 22nd itself. Very well.
Coming to that, can give the can. Yes. Application has been taken out by yes, by the income tax officer seeking, praying for addition, praying that he may be added as a party respondent to the proceeding. It is pleaded dues over one.
But that's not against me. That's alleged, my lord. This is subject to adjudication.
It dues over 1.66 crores is pending against the appellant company. Having heard the learned counsels for the appellant company and the applicant, we are of the opinion, we are of the view, as the assets of the company are put up for auction, applicant requests to be added as a party respondent, subject to, without prejudice to rights and contentions of the appellant company and others in the matter or any other collateral proceeding.
Grateful. And my lord, in his application, Lordship will give the directions to file affidavit.
This is only addition of party.
Yes, but he has got an application also, my lord.
No, this is that's a different application.
Yes.
So this can is disposed. Can is disposed. With this, appellant shall carry out the amendment in the courts by Monday and add so and so as party respondent.
And serve a copy to them also.
Serve copy of the pleadings to the added respondent. Can is disposed of. And what is the other can? So affidavit in opposition we filed to the can.
Yes.
4 weeks. Reply 2 weeks.
512. No. And now, my lord, 512, Lordship will give the direction.
512, we are not giving any direction as of now, correct?
No, Lordship said, because otherwise it will not come up before my Lord.
512 will give direction after we consider the application for reduction.
Of my Lord?
Application for reduction of price.
No, but that will have no, my Lord, implication on that.
512 will take it up later on. As of now, we consider this application and his application. We have given you liberty to file affidavits. 512 we'll consider later.
Only thing is that, my Lord, at least, my Lord, kindly gives it on the next day, because what is happening, my Lord, statutory compliance I cannot, my Lord, because the companies have been struck off. So, my Lord, if I am able to succeed before my Lord, then, my Lord, I can have the statutory compliances made, because those are violations, my Lord, which will come under the NCLT, my Lord.
We'll consider.
Kindly, my Lord, I'll renew that.
Mr. Chakraborty, look into 512. What is? You don't have copy.
My Lord, I will serve again. Lordship can direct that I'll give him a copy again.
Serve it in front.
I will give him one.
Then 512 on 22nd will take.
Very well.
All right. We'll give directions about 512 on 22nd.
We'll give tomorrow itself, my Lord. By all of them, including income tax also, my Lord.
Now you are on bail, right?
Yes. That is why I was.
It is evident.
Yes, I didn't say to my learned
Mr.
friend.
Banerjee, it is evident.
Evident means?
The vehemence is evident.
But I am only, my Lord, on the. If it is under the law.
To you, your vehemence is evident.
Lordship will not see it in that way, my Lord. But then
we will consider.
I am happy, my Lord,
We
to
will
pay the
take
depositors.
all these into consideration. All right.
But the answer, my Lord, to my learned friend is that my Lord, nobody could have come before my Lord, because in 22 he has got bail. 2023, 2017, I couldn't have contested the proceedings.
We know. That's why we are saying the vehemence is evident.
Many application and so many.
Vehemence is evident.
But my Lord, I will see that actual depositors are paid off, my Lord.
Where is CBI lawyer?
CBI. CBI, yes.
We like a report as to the progress of the prosecution against him. How long were you in jail?
8 years.
8 years. You plead guilty now.
That
plead guilty and say that your sentence of can be set.
That, my Lord, I am not briefed, so my Lord, I cannot my Lord, say anything regarding that.
Check out on your status in the criminal proceeding. You are 8 years in custody. That is why he is released on bail. It's protracted detention.
I believe, my Lord, these financial.
How long in Sharada the accused is in jail? Since 2013.
9 years.
More than 10 years.
Same. 2013 onwards, he is also there.
Your client also?
Yes, together only all of them.
No, 14.
The cases were transferred by the Supreme Court in 2015. Before that, you were already arrested.
Yes. 2014.
You were arrested.
2014.
In 2014, or he's saying 15. 14. And in Sharada, this Sudipto Sen was arrested in 13. And in Rose Valley, this person,
I think later, much later.
17,
much later.
So yours and Sudipto Sen, maximum periods of detention you have already under.
He's still inside. He's so, I believe, still inside, Marod. He is still there.
You will have to cover up that portion. You should have waited for 10 years.
Marod, now that the matter is over, Marod, Marod, this is an academic thing. Marod, I believe, Marod, if your Lordship sees from the point of view of the Companies Act and the corporate law, Marod, I believe the whole intention should be instantly give back the money, my Lord, to the depositors.
That you had never intention. That's why you had.
My Lord, I want to know, my Lord, I was behind the bars for 8 years. My Lord, what was in these 8 years? My Lord, I want to know, my Lord, this is between academic, my Lord, I am not making any submissions. What has happened in these 8 years that the depositors could not get the money?
Because so many applications could be filed on behalf of your client.
No, there are none. There are none, I'll show. There are none I'll show by this client.
Sir Banerjee, if you see the course of action, nothing was done
I think 2016, 17. Then this court intervened and started making some.
But I'll be very sorry, my lord. My lord's judgment I'll rely upon. Lordship on the first day has given that one liner saying that immediately ascertain the debt of the depositors. Till today, my lord, there is not a scrap of paper before my lord. My lord's judgment I'll show. That is exactly my argument.
That is why we had indicated to you. There may not be any clarity as to the maximum debt, but there is definitely a certain amount of demands have been placed before the one.
But that's exactly what I'm saying, my lord. 8,000 pursuant to my lord's direction. We have got that details.
Otherwise,
80 crores,
and
90
so far as,
crores, my lord, at
so
the
far
maximum.
as quantification is concerned of your liability, that has already been done by SEBI.
No, my lord, liability is not, my lord, to that extent. Depositors' claim is to the extent of maximum 80 to 90 crores. If I am, my lord, saying what has come from the
claim before the one-man committee.
Yes.
And so far as SEBI identifying the amount.
That's a question of violation. There, my lord, there is no financial, my lord.
There is.
Illegality, my lord.
There is, because SEBI has calculated the amount of money that you had raised from the market without taking permission or in compliance with.
Not in this case. Not in this case, my lord.
Total group company case.
No, my lord, no, my lord. This case, my lord, I'll just indicate, lordship will, I'll just indicate. In this particular matter, Justice Banerjee, as he then was, now we have to say, Justice Banerjee, my lord, had the occasion to take a matter with regard to SEBI. As far as MPS is concerned, Justice Banerjee held that, my lord, under, my lord, the CIA's guidelines, this is one of the companies, my lord, which can raise, and it should be given a provisional registration. Now that registration was given.
Only one company.
Only one company, MPS, my lord, Greeneries, I'm saying. I'm not talking about others, my lord. Now, my lord, that was given. All of a sudden, my lord, in a violation, my lord, of a law, because in terms of Justice Banerjee, compliances were being made of, my lord, 14Y, my lord, and notification was given. My lord, that stopped it. This company, that is why I want to argue. I may lose, I may win. But, my lord, the question is that to argue before, my lord, this particular company, my lord, is not under that hodgepodge. That is why I'm saying, my lord, if it is depositors,
we will examine.
Yes, interesting point, my lord. That's what we got, my lord, from by in terms of. Well, we have not got first.
There is Mr. Ahmed is there. When Mr. Ahmed can make his submission, find out exactly what are the number of depositors and what is the claims made.
Claims made, exactly.
Right. That can always be looked into. We are not
Grateful.
really impressed, but then, so we are on the limited question of the auction and your objection with regard to the reserve price. You file your affidavit because.
কোনটা এটা কি ফাইল করে দেবে কি আছে কি সার্ভিসে
Auction notice.
My lord, pursuant to my lord's earlier order, there is certain affidavit of service. We have served on them, my lord, be kept in the record.
Yes, next matter.
Great.
So MPS lot is over. Now next one. সব পাইছে দেখবে এখন কিচ্ছু করার দরকার নেই।
My lord, in this particular matter, my lord, we are looking after the matter, my lord. The last auction was in 2022. My lord, with that regard, I have instruction, but it has failed, my lord. There was no bidders.
All right, Mr. Banerjee submits.
My lord, may I mention another matter, a writ petition which has been filed against the same company and for an amount of.
Give that number. Mr. Banerjee for
tagging the matter.
contends that the auction did not yield fruitful result. He seeks time to take instructions in the matter.
matter will appear in the monthly list of April 2024 list along with WPA so and so.
Deeply obliged.
Next. Monthly list of April.
Same. My lord, here also, my lord, on the last occasion, my lord wanted to know whether we are looking after the matter, my lord. Here, my lord, some recoveries have been done. Near about 1 crores we have till date.
Report.
We will file a report then.
Report be placed on Mr. Banerjee 6 time to submit report. Monthly list of April. Next.
69, my lord. I'm for the company, my lord. In this matter, one of 3 issues were pending, my lord. Your lordship has directed that, yes, inspection of the properties for repair. No, my lord, kindly. Well, I'll refer to the report only. I'll refer to the report, my lord. They themselves have said, my lord, kindly take up the report once, my lord. Report to the. My lord, report dated 21st of December 2023. Filed by the EOW. Department of Directorate of Economic Offense. এইরকম দেখতে। পুরা all drama দেখি। Kindly
This. Yes.
Malad, kindly third page, Malad, from top. This is the this is regarding the Digha property, Malad. Kindly may I place, Malad, last 3 paragraphs. During joint inspection, it was found that in each room mentioned above, door, window, so and so were got damaged. Then, Malad, but the condition of all rooms are almost good except the wall of so and so. The above mentioned portion of the so and so needs petty repair.
So there are some repairs necessary.
This is one in respect of Digha property. Right. Kindly come to page 6. This is in respect, the last paragraph is in respect of Baliganj Place guest house. Page 6 after the photographs.
After the photographs. Yes.
And on the top, some page number has been given.
No, forget it.
This is, my lord.
Next.
This is Baliganj Place guest house. That is also inspection, dilapidated, dampish condition, etc., etc. Outside
the inspection, we found collapsible gate and lock was intact, but wooden door was damaged. Visited every section of office room, so and so. The wooden door.
Last page, page 7, my lord.
We are seeing that. Through collapsible gate is intact. So there is some repair necessary in
all
both the properties. So
let the repair be carried out by the company people in subject under the supervision of the EOW. Then thereafter, my lord, we will come
and
back
you give a report. Peruse the report submitted by এটা can number. This is
my lord, can number, my lord, 3, 4 and 5. No, my lord, 4 and 5.
Please give correct number.
1 second, my lord. 4 and 5, my lord.
4 and 5. Peruse report of report submitted by EOW, Directorate of Economic Offences, Government of West Bengal, with regard to the state of the properties, namely,
my lord, Digha hotel,
namely mini holiday home,
and in Digha,
situated at in respect of hotel premises at এইখান থেকে
Lot number 19.
and
Page 6, my lord, the 10/5 Jamini Roy Sharoni,
yes,
Kolkata.
and the guest house situated at premises number 10 Jamini Roy Sharoni,
10/5.
Kolkata.
And my lord,
19.
And next page, my lord, office room number 334, Crooked Lane, 1 Crooked Lane.
And office rooms number third floor, office room
Premises number 1
at,
Crooked Lane.
being room number 330 floor, third floor, premises number so and so. The report states, the report records joint inspection was conducted in the said properties, and it was found that certain repairs are necessary. Full stop. Both the and it was found that repairs are necessary for proper maintenance of the said properties. Under such circumstances, learned counsel for the respondent company / applicant seeks leave to make the repairs at their own cost. This is not opposed by the learned lawyers for the petitioners or EOW. Full stop. Under such circumstances, we permit the respondent company applicant to undertake necessary repairs in the aforesaid properties under the supervision of representatives of EOW, Government of West Bengal. Further report shall be filed by EOW on the adjourned date. When do you want this matter to come? At least 2-3 months it will
Yes,
take.
ma'am.
So let it come in the monthly list of April.
April or May, my lord.
All right. May. Will there be a monthly list? Yes. Monthly list of May 2020.
My lord,
One by one. 4 and 5 is
my lord. Now, my lord, can number 3.
Can 3. This is 4 and 5. Now can 3.
Can 3 is, my lord, the amount lying with the learned Registrar General be transferred to the one-man committee and file a report. Thereafter, we will take it up from there.
For Registrar General?
Orko Kumar Nag was here, my lord.
I'm appearing for the registrar.
Yes, so it is with the Registrar General.
That was the last position, my lord, but latestly, my lord, I had sought for the instructions, my lord, it is yet not.
My lord, may I submit, my lord? There are discrepancy regarding the quantum amount lying with the Registrar General.
Let us do that.
No, my lord. Let them transfer it and file a report before your lordship. We will take it from there. What is the amount? We are saying X, they are saying Y.
Let us first find out that.
As your lordship.
Mr. Nag, for High Court administration, shall submit report with regard to the amount lying with the Registrar General.
As on date.
Yes, today, as on date, with the amount presently lying with the Registrar General.
My lord, let this can, my lord, we come up on 22nd of
On
February.
22nd, correct?
Yes.
This can will come up on 22nd.
My lord.
Okay.
Last pair, my lord. Regarding the liquor stock, auction of liquor stock, my lord. I have received a report from the Excise Commissioner. My lord, we are considering it because, my lord, the quantity as mentioned in the earlier report is not matching with this e-auction thing, my lord. My lord, give me 2 weeks time to come up with the exception.
Liquor issue will be.
My lord, kindly appreciate, my lord.
We are not passing any order on the liquor issue. On 22nd, we will give a date on next month for considering the liquor. All right?
My lord, kindly.
Now your matter. Tell us.
My lord, kindly takes up WP number 498 of 2018. But this is, my lord, if I may directly state the crux of the matter, I am neither a claimant nor a depositor in the matter, my lord. I am a landlord of a property, my lord. My property was tenanted, my lord. The Pincon Group, my lord, was a lessee in the company, in that property, my lord. And my lord, if my lord kindly looks at my reliefs of my
Let us see.
Repeat it.
গড়িয়াল সে
হ্যাঁ স্যার ক্লাব হয়ে গেছে তো
चलो क्या जाए
একটা কপি আছে
Also, to look at business. Also, last time to say तो लाके धमकाया ऐसा सब लगा काम
मालिक कोई
लेकिन आपको कोई पार्टी नहीं
who is the
मालिक को Do you have a copy of this? Let us see who are the respondents here in your matter.
এগিয়ে দাও না এটা দেওয়া যতক্ষণ খুঁজে পাচ্ছে
takes up my copy.
Is your property attached by who has attached?
এটা কি seven race course
One second.
Directorate of
ওইটা?
Economic Offenses.
Wait. Bablu, take response.
My lord,
Give your response to it. Two things. No, you
I was
are the
planning
lessee of
that-
the property. They have attached it. Now, what do you want?
And I want my lord,
You can't get it from here, sir. This is a valuable right so far as this client is concerned. You have to file a suit for recovery, for eviction.
yes,
Eviction and recovery. We can give you that liberty, that much. Mr.
you
A.
looked at my prayers, my lord.
Yes.
Because, this seat, madam, I believe subject to correction, my lord, this petition is not maintained well before this only.
So we'll release it.
Release, my lord.
So what do you want? Again, there will be conflict. The single judge will say, the honorable single judge will say,
go to the
all
bond
these
unit.
assets are before the division bench. Oh, there may be conflict of decision. So let us. Two judges are better than one judge. All right. So let us consider your application. What we do is we give a copy particularly to the company. You've made the company a party.
Pincon is there, my lord.
Pincon,
Yes,
you
ma'am.
take notice.
Very well, my lord.
All
I will
right.
tell, sir.
And we are keeping it on 22nd. Please take it.
Mine.
Read petition.
copy here.
এটা হচ্ছে WPA.
498
Why WP only? This should be
Is the
WPA.
original side
Original site, my
Oh,
lord,
WP 498 of 2018. Copy of the writ petition be served upon Mr. Manush Dashgupta. Mr. Manush Dashgupta, learned counsel for respondent number for the private respondent number 5, as well as upon learned counsel appearing for state of West Bengal. Respondent number 1 to respondent number 4 hearing.
My lord, kindly direct Pincon Speed Limited is in liquidation now.
All right.
There's the RP be served upon RP.
Please give him the.
Yes, my lord. And 6 I can appear.
No, we give direction for 6. Mr. Dasgupta contents respond number 5
is in liquidation.
Has been order has been passed, winding up.
Yes,
or
my lord.
RP has been appointed.
Yes,
my lord, it is pending before the Honorable Supreme Court, my lord.
All right, the RP is appointed.
Yes, yes, RP has
The
been
respondent
appointed.
number 5 is in liquidation. Petitioner is directed to amend the cause title and add the resolution professional appointed over the affairs of the Messrs. Over the affairs of over the assets of Messrs. Pincon Spirits Limited as a party respondent. Please give the particulars.
Name of the RP.
Name of the RP.
Binoy Kumar Singh.
Please give the name. We will give the name here. All right, to give the name here. Then why didn't you add him as a party? liberty to amend the cause title of the petition and add the resolution professional as a party respondent. Copy of the petition be served upon the resolution professional. Affidavit of service be filed on the adjourned date, 22nd. You please take, Mr. Bosumonli, take instructions. We can give whatever, we can't give a liberty to take possession here. So we will give him liberty to take appropriate steps in accordance with law. Yes.
Deeply obliged. Deeply obliged.
वो लड़का आ गया नाम दे दीजिए आज हियरिंग करना अरे भाई 4 and 5 মেতে আসবে অন্যটা 22nd এ আসবে yes next group who is in the next group Rose Valley yes
My lord, in this matter, my lord, appearing for the pursuant to your lordship's direction, my lord, the website has already been in a not at all functional, but it is in a process of functioning. So a report may be filed by the ADC on the next date. Any date will be fixed by your lordship because report of the website is also necessary.
We'll do that. We'll do that. Yes, Mr. Bhattacharya, your matter.
My application is CAN 8 of 2024.
Yes.
In that, my lord was kind enough to pass an order.
You know the order, but you see what is the development thereafter.
They were to file a supplementary affidavit regarding the SFIO procedure.
Mr. A.
Pursuant to granted by your lordship, may I submit my short supplementary affidavit? There are only 2-3 paragraphs. It got me look into, but so far the some confidential documents are concerned. On the last occasion, I undertook to come with some confidential document and seal cover. My lord, may kindly look into.
কাটটা বলছো গো কোনটা কি বলছে কিছু বুঝতে পারছি না আমার
এটা খুলে দিয়ে
কপি দাও
এটা কপি
They are saying that these are matters of investigation presently and would not like to share it with everyone.
For your lordship's convenience, we have prepared an index. If your lordship kindly have a look at the first 3-4 pages, which is with regard to the monetary transaction. That is the dispute here in this case. And summons have been issued for only for this purpose. So
What is the monetary
transactions?
Then
the statement of the original, the main director of the Rose Valley Group of Company. Only may I provide kind attention so far only question number 13 and answer given by that person.
ওইটিরিশ ধরবে
You are investigating land bank.
Yes, we are investigating real estate land bank limited.
Mr. Bhattacharya, have you represented real estate land bank company anywhere? You have represented.
Milord, as far as I know, Milord, I used to represent Milord Rose Valley and its various subsidiary companies. And Milord, it is possible that Milord, the bills used to be settled at some point of time in favor by this land bank. But I cannot, Milord, offhand say, Milord, which bill was settled by land bank. But land bank definitely had
Go and respond to the notice, because why I tell you, we are not divulging the basics. The idea is, although the land bank may have some shareholding overlap with the other group companies whom you have represented, the thing is, you do not appear to have any professional relationship with land bank, and there was payments or transfer of funds from land bank to your account.
just Milord.
So that needs to be clarified. It is no, it is possible. What he is saying, what we would propose to do, Mr. No, listen. What we propose to do is subject to hearing Mr. Bhattacharya. We understand what you are saying, and in all probability, what Mr. Bhattacharya gives as an answer is a very possible answer, that if X has represented client A from the account of client B, payments can be made. It is not that yes. So it will not be a fraudulent transaction, but only thing is, it has to be explained that the payments were made by a sister company with regard to the deposit, with regard to his legal services rendered for the other companies.
Milord, kindly looks into the summons, Milord, that
lecture or you clarify the position.
Milord, the summons obliges me to give a list of other documents.
We will ask you. We are not required to bring documents. What you want, you go, you meet the officer, and a further report will be given. All right. What we are not asking you. You have asked for 7 years. You understand? This is very embarrassing for him to bring all. You see your notice.
As well as what is called for also when you pass it on. A direct line.
We have followed the submission. वगैरह उस कंपनी से लाया है, वो बोल देंगे.
Milord, kindly pardons me, Milord. An advocate will go to the SFIO
office. All that lecture we don't want. You are President of India.
No, not that. Milord, what have I done? The question is that.
I have done nothing. Discrepancy here. The discrepancy they say with regard to the accounts. You just talk with them and explain it. All right. Because the problem is the protection that you are seeking does not extend with regard to the company they are investigating. Land Bank is not, which is why first question we asked you. Have you represented Land Bank at any point of time? Show me one piece of paper. If you fight on this, show me one piece of paper. If you don't, we can simplify this. All these ego. We have understood what is the.
My application. Nothing.
It is not none of your issue.
Yes, it's not my.
They are investigating Land Bank. They see large transactions between Land Bank and a member of the bar. There is a statement he has not represented Land Bank as in his professional capacity. Usilie, if they can place on record that yes, we have appeared for Land Bank, these are the orders, I will immediately enjoin them from taking any steps.
Direct Mr. Bhattacharya to be present with 2 photos.
Our photo.
No, or ID.
You be present. We will direct lawyer. Yes. No, my lord. We will direct the advocate on record of FSFIO to identify Mr. Bhattacharya. You are making fun of. No, sir. These things should not be proper.
You should go.
No, Mr. No, Mr. Please don't do all this. We also feel the respect and dignity of the lawyer should be maintained. Huh? Don't do all these things. He is not a fugitive. Why did we entertain? We would have last occasion accepted that we do not have jurisdiction in. We have laid down the reasons. He is in effect an officer of this court. He is a member of the ADC. The ED is a representative in ADC. There we understand your statement of the principal director. He is saying that he has not represented land bank.
That he has represented land bank.
Can you place something on?
No,
File an affidavit.
Very
we will keep it next week or 22nd. Huh? If he has represented land bank, then what we would request you, don't issue a notice. He will give a response in writing.
That will be.
He will explain in writing. All right,
Very-
Mr. Bhattacharya.
that is
Please
all right.
show us why Mr. Is arguing he has certain materials which may have misled the officers. It's not the officer's fault. A person under investigation has stated Mr. Bhattacharya is not representing land bank as a lawyer, and therefore they felt, how is it Mr. Bhattacharya's account large transfers have been made, which is of a significant. Now, that is why the first question we asked you, we don't want to divulge what, how much, etc. They are subject matter of investigation. Yes, we'll keep it in sealed cover. We'll keep it with you. You place on record whether you have represented land bank in a professional. If you do that, we will invoke the restrictions under the Companies Act, and we will say that the notice is injuncted. However, you can communicate to him for clarification, subject to communication. But notice, don't issue notice, because then the restriction as a lawyer, he is not required to divulge. He is not required. That is not required. Supplementary affidavit is placed on record.
But so far as banking details are concerned, we have to assert something like some
দেবে না, করবে না।
and should be recorded.
We will consider that issue once we get the supplementary affidavit. If this man has represented as a lawyer, then whether you had the jurisdiction to issue the notice has to be gone into. Otherwise, this will become a legal question then. Which is why the first factual clarification is necessary. Whether you have represented land bank. If you have represented land bank, even if not in this case, some other case.
Yes.
Place on record that. Then you are a legal representative, a lawyer. Your argument of the exemption comes into play. We will examine that at that time. But the factual matrix.
I shall file an affidavit.
This is can, Mr. Bhattacharya?
No, can 8
Can
of
8
2024.
24. Mr. Nondi for SFIO with Mr. Ghosh.
No, I have ED, my lord.
Oh, ED. So see your brother doing it. Oh, yes, with Mr. Nondi with Mr. Tiwari for SFIO places supplementary affidavit. They also place confidential documents before this court to justify the issuance of the impugned notice. We have perused the documents. We have perused the documents. We direct the writ petitioner to the applicant to place on record, to file a supplementary affidavit, clarifying whether he has represented Messrs. Land full
real estate and land bank.
Real estate land bank private limited in his professional capacity or not. Affidavit be filed by 16th.
My
Wow.
Next is the chuti bollo.
Kindly makes it, my lord, 23rd. Or
22nd.
19th. 22nd, my lord is returning.
We are keeping it returnable 27, but at least Mr. Nondi should go through the
19th?
affidavit and take instructions from the officer.
19th is all right.
19th?
Your lordship's gracious.
19th, supplementary affidavit shall be filed on 19th. Reply, if any, by 21st. Matter will come up on 22nd. All right? Hey, India Limited. How you are giving India? Under the Companies Act, you cannot use the word India until and unless it is a government company.
কোনটা আমি কি করলাম?
Your client, you say, is a lawyer of this company.
আমি কি করব?
Messrs. Real Estate and Land Bank.
What that is also my fault.
I've never said your fault.
I don't know.
I said that you need to explain that your client, a legal representative and a lawyer, as you claim, of a private company takes a name which has India as a part of it.
ইন্ডিয়া কি করতে পারে?
It is Real Estate and Land Bank. Little knowledge that we have under the Companies Act, you cannot use India as a part of your name until and unless it's a government company having 51% share holding. Is this the name of the company? Real Estate and Land Bank India Limited? Wow. From the name, deceptive. From the name. Lawyer. What sort of advice he has given to the company? Huh?
And all things cannot be answered.
All things can.
I can only resist, my lord, but not answer everything.
Then accept the summons.
No,
They will give a cup
I'm
of tea to
resisting
your
that.
client.
I'm trying to resist.
Also go even
You have a joint conference in the SFIO office.
SFIO office is the problem.
I'll be there. Yes, Mr. Nondi now has agreed. If Mr. Vishwarup Bhattacharya goes,
No,
Mr. Nondi will also go.
no, Vishwarup will not.
Why not?
No.
Your friend,
I have never been not faced any summons. Apart from my,
we have never said you are to face summons. You are to assist a person who is your dear friend and your client now. Next day we'll decide on the combination. If we don't agree with Mr. Vishwarup Bhattacharya as to the legal bar, we will decide on the combination who will visit. Next time, SFIO will be a bit cautious in issuing the summons because of the hospitality required.
We don't actually the money for a cup of tea.
Hospitality.
Right now.
Achha.
I have been directed to stay in High Court up to 10 p.m. Until and unless your clients concludes the interrogation of what group of company. So I am now detained. And my lord will also be staying here till 10 p.m. So it's another problem.
My lord generally stays here.
Can number 6.
Take back the original records for
Please keep it with you.
My lord, so far as the can number
Confidential documents are returned to Mr. Nondi. He is directed to produce them on the name adjourned.
Yes, definitely.
What company? India Limited.
No.
We don't know company law.
I've only learned to look blankly.
So what blankly? If you have no answer. To next time, we'll dismiss your application on this. That they will have to either change the name of the company or face the interrogation.
can number 6.
Yes, next matter.
My lord, can number 6 in Rose Valley matter. My lord, it is the application for my learned friend, whether he has made an
Mr.
application.
Ghosh, there was one thing, the representative of ED has now been,
My lord, can number 6 I have filed. My lord, that has already been decided, my lord, on 29th March 2023. But they are to make an application before the, my lord, appropriate court for release of the sums, my lord. That has already
Can number 7, can number, Dhanan, like to. Can number 7, my lord, I have filed. That is for recalling of that particular order, my lord. That has to be, my lord. What happened in can number 6? The can number 6 has not been decided because it is an application for recalling of one particular order. And can number 7 is also an application for recalling. My lord, more than crores, 1,500 crores of person has to go before the special committee, special court. Your lordship on the last occasion. My lord, I am only just making one submission. My lord, your lordship in the last occasion said that the amount which are lying with, because there is an application, my lord. I'll show you, your lordship. There is an application that ED has made that application that it is not possible for them to sell any properties. So the special court has given the entire auction process of the cards of the Roseberry company by the one-man ADC committee. So, my lord, similar way, my lord, what I am submitting, my lord, let the entire money be.
Look into this matter, because the law is that the special court is to deal with it. Now, if the special court not in a position to go ahead with the auction because of the various paraphernalia, if that the one-man committee can act as a representative of the special
My lord, in Shadoda matter, my lord, there is an affidavit by ED. In Shadoda matter, there is an affidavit by ED that let the amount be transferred to the special one committee, and special committee will transfer it to the ADC for the purpose of disbursement. And so far as the auction,
go through this issue. So
This
that
is
the issue is not one to fight about. If this amount can be disbursed, tell us a convenient way of disbursing the amount. Give us a convenient.
there is no infrastructure, my lord, in special court. Then, my lord, can 6 can be taken up because it is pending.
6 and 7 will take up together.
That has been already been decided in 29th March 2023.
No.
Yes,
There-
that order, my lord. May I read the order, my lord, relevant portions of the order, my lord. Well, of the view that the court having jurisdiction and control over the said sum could be approached with the appropriate facts. It is for the court to consider whether they will release the amount or not. In the event the court release the said amount, the question of applying the fund for the purpose of functioning of the committee would arise. So there is already order, my lord. We have
again repeat.
My lord, we are of the view that court having jurisdiction and control over the said sum should be approached with the appropriate facts. It is for that court to consider whether to release the said sum or not. In the event the court releases the said sum, the question of applying the fund for the purpose of functioning of the committee would arise. In those circumstances, we adjourn this matter, Sergeant Sir.
All right. So it's not disposed of. There is some direction to approach the.
Let the not yet approach, my lord. 1 year has already been lapsed.
Now, have you taken out an application for modification of that? Can 7 is an application for modification of that order passed in Can 6. So the main application to be heard today is Can 7.
Can 6 and 7, my lord, then, my lord,
together has to be heard. We'll keep it in March. 22nd, there will be too much pressure on us. All right. But then it's not that
easy.
It's not that easy. You don't understand this. Under the PMLA Act, the entire jurisdiction of disposal, even at the interim stage, is of the special court. Correct? Now, if that is the law, is it possible even under Article 226 to alter the law and say, no, the ADC or the one-man committee is going to do it? It can only be done, in our understanding, by the special court appointing the one-man committee as its representative and doing it. And we can oversee the entire exercise.
Certainly, my lord.
Yeah, bhaiya. Otherwise, it becomes violative of the law. You understand, Mr. Chakraborty, we appreciate your concern for the depositors. But in passing the orders, if we violate the law, it will not help you. In fact, Mr. Ghosh is assisting you in saying that you go, he will.
Is it possible? The special code is referring the entire matter to the in case of any of the cards are concerned.
That is why we have given you that prayer. They go to the special court and say that amount be transferred to the ADC and the ADC will take appropriate.
By your lordship, then it will be.
Are we the special court?
No, but
Tell us.
that
That observation we have already given in 2023. If you choose not to act as per the observation, what can we do?
you respect, let in the month of March,
Yes. That's what we feel. We don't want to overreach and take over jurisdiction when the jurisdiction statutorily lies with the special.
ED in case of Chadoda is making the submission.
What ED makes a submission, then when you are arguing, you place it before Mr. Ghosh that this is the submission made by ED. Absolutely.
But in GA7, my lord, may I file my affidavit in opposition?
Which one?
It's the original side matter. An application has been filed by SFIO for modification of the order staying the proceedings filed by SFIO before National Company Law Tribe. And it is affidavit in opposition.
Affidavit in opposition in Mr. Nondi, your matter
GA7.
GA7. Affidavit in opposition has been filed today. Have you got a copy? Correct. Have you got a copy of that? All right. Affidavit in GA7 of 2023. Affidavit in opposition is filed by the respondent company. Reply, if any, be filed by the adjourned date. Matter will appear on 22nd.
But we have also filed another application being GA8 in original side. But in that application, we have come up with certain cases. Those are pending before various tribunals. And orders are being passed for dispersal of the amount. So, earlier, we have also moved an application. The payment money in that event, the complaint cases have been lost in respect of the same investment investors. And in some cases, orders have been passed. Even some cases have gone into the execution stage. But this is GA8.
We'll consider GA8 in the month of March. Not now.
But we have served all
so far as SFIO matters, we are keeping on 22nd. All right. And so far as Mr. Chakraborty's application in March again. The monthly list of March, it will come on March. Next first Thursday of March, you will get it. All right. First monthly list of March kore debe. GA8 and what is your can 7?
6 and 7.
6 and 7.
6 and 7.
All right. Chalo. GA6 and 7.
GA6 disposed of.
Yes, now GA6 has not been disposed of.
No, that is not can, Mala. That is can 6.
Oh, GA6 has been.
GA6
sorry, can 6 has not been disposed. GA6 has been disposed.
GA6 has.
Yes. Yes, next matter.
Remove করবে? 77.
Brand value. This is part of Rose Valley.
Yes, Mala. Brand value is a part of Rose Valley Group.
Part of Rose Valley. Yes, what is the issue about brand value? Oh, the SFIO.
What has happened?
Yes, Mr. A.
As far as the EDC is concerned, kindly give us a date. The EDC has not considered this.
Please consider it on the prayer, Mr. Cord for ADC. seeks time to take instructions. Matter will appear in March 24. Monthly list of March. Yes, Mr. Ghosh, you heard for?
I have the claim against brand value, which has been advocated before the TD SAT.
OTD. Yes, you can proceed. We have clarified that in your application.
Because you know, seeking leave of your lordship before the TD SAT, the only ground that they are seeking adjournment is that the
No, we have made it very clear that so far as the TDSAT matter is concerned, we'll proceed in accordance with regard
only one. Only one humble submission we have, my lord. But I've just talked to Mr. Chakraborty. Well, we can sit with him so that it can be resolved because the company has no money, ban value. There is a decree against TDSAT. Some orders have been passed.
Mr. Bhattacharya, so far as your company is concerned, it can always enter into whatever arrangement it is, but the assets have been transferred to ADC. As a member of the ADC, take a decision on that point and.
But the subcommittee has been entrusted to look into this.
So let it be.
We are trying to
take appropriate steps.
My they can wait for some more time.
Not granting you any liberty. We have made it clear. You made an application that you want to proceed before the TDSAT authorities. We clarified that you can proceed. Now, if you choose to approach the ADC for for a decision for liquidation of your liabilities, so be it. We are not standing in the way.
The ADC is of the view because the matter before your lordship, they will not entertain unless your lordship grant that.
Mr. Kaur will apprise us of whatever developments take place. Mr. Kaur, whatever developments you apprise us. Yes.
The last line, if your lordship so pleases, that already the website is in the process of functional. So a report may be placed before your lordship.
Who is preparing the website?
One person has been chosen by the Hon'ble
the ADC. All right. Mr. Kaur shall also submit report with regard to the setting up of the website of the ADC website of the committee.
You should incorporate in the minutes.
Incorporate in the minutes. Where last line is not necessary. Because it's an internal affair of the ADC. Let it be. Take it. It's actually let it by a bit. So I don't want to be so much. We wanted to merge, but the company says that they are going to fund it. All right, next matter.
My lord, in respect of 82, my lord, there was a direction on me, my lord. Somehow there is certain development. I will kindly keeps it on 22nd, my lord. I will be able to.
22nd March.
March, very good.
One thing, but again has been filed, my lord, saying that my lord get the property disposed of and my lord.
March list along with can so and so in the monthly list of March. Next.
In 85, my lord, I am appearing for one of the, my lord, directors named, my lord, in the petition, my lord, police has informed us to appear before my lord.
Yes, we were not appearing, that is what.
My lord, we were directors very long back. We have given our resignations. My lord, in the ROC, my lord, it has been accepted, and the present director before the company court has sworn an affidavit that
they filed a affidavit in.
A copy of the writ petition may also.
A copy of the writ petition we handed over. You are appearing for
the item number 85, 86, 86, item number 86.
86. You are appearing in 86?
86.
He's appearing in 86. 85 who is appearing, you are not appearing. So 86 you are for respondent number.
No, I don't have a copy. The number I don't know, but it.
All right, give your name, client's name. so that Mr. A appears for respondent number blank. He seeks liberty to submit an affidavit to the writ petition. Copy of the writ petition be handed over to him in the course of the day. Opposition be filed 1 week. Be filed by 5th of March 2020, by 4th of March, or you file the opposition in this month so that it comes in the monthly list of March. Opposition be filed by 26th of March. Reply, if any, by 29th of March. Matter will appear in the monthly list of March, February, monthly list of March 2020.
Respondent number 21.
Respondent number 21 in 86, item 86.
Along with can গুলো দিও হ্যাঁ from can পারবে সাথে দে দাও আমি
কাঁদিলে ব্ল্যাঙ্ক রাখবে যখন চাইয়ে নেবে এর থেকে। Yes, next matter.
88, I am for the petition. On the last occasion, I was directed to serve upon learned counsel for SEBI, my lord. I have served, my lord.
You're for SEBI?
My lord, may I pray for not this week only, my lord. I am led by himself.
Monthly list of March.
Deeply obliged.
Next.
My lord, in 89 and 90, there was a previous direction to file opposition, my lord. They have to file their reply.
Affidavit in opposition is placed on record. Reply be filed. Matter will appear. Reply be filed within 2 weeks. Matter will appear in the monthly list of March 2020. Next.
91, lordship, I am for the petitioner, lordship. Lordship, 92, I am for the petitioner. 91, I am for the SEBI, lordship. Lordship, may I file my evidence of service, your lordship? 92.
Yes.
91.
Give the number.
You are 91, no? 91. I am applicable 92.
That's what we are saying. List along with so and so in the monthly list of March 2000.
Lordship, the evidence of service can be kept on record, your lordship.
Evidence services are kept on record. Next.
'93, my lord, I am for the petitioner. This is a criminal revisional application, my lord. Honorable single judge, my lord, released the matter. Thereafter, my lord, coordinate bench.
What do you say? You will? You will use an affidavit.
My lord,
Affidavit in opposition be filed within 4 weeks. Reply 1 week. Matter will appear 6 weeks hence. Next.
94 টা বললি?
No, 94.
বলো না
থাকবো।
by the report.
He's not due to wrong place. It's on record. Yes.
This is আমার 93. নাম দাও। নামটা দাও।
Expenses lawyer. It just harassing. Yes.
The amount of money has been that only because this exemption are not it is giving but because whereas the inter takes up the inter newspaper directionally above the above the private respondent.
Mr. Joymalya, in this matter, as the police, in spite of notice, private respondents are unrepresented. Director General of Police shall take steps to notify the respondents with regard to the pendency of the proceeding and direct that they shall be present personally or through their learned lawyer on the adjourned date, failing which coercive steps shall be taken against them. All right. Matter will appear 4 weeks hence at a date there. All right, 4 weeks. Yes, next.
Right, please, Lordship. Verona Commercial Credit and Investment Company Limited, they have been selling their land on repeated occasion to different persons. I am one of the victims of such. 53.
Mr. Banerjee, have you met SEBI party?
Your Lordship, in this matter, I appear for SEBI, Your Lordship. We had been directed to file a report, Your Lordship.
Yes.
We have just received the reports. We'll file it in affidavit, Your Lordship.
All right. Find out whether it falls within any of the violations under the SEBI.
Much
Right.
I'll do so, Your Lordship.
Otherwise, we'll release the matter. You can go.
The authority may continue with
Understood, Your
statutory authorities, the police
Yes,
authorities.
right.
Understood, Your Lordship. Much obliged.
I have a copy of
Mr. Learned Counsel for SEBI seeks time to submit affidavit. Matter will appear 4 weeks hence.
I'm grateful.
Next.
दिलम ना अपने 95 दिलम तो दे दीजिए ना
96. And this is my lord, I am from the petitioner, my lord. On the last occasion, your lordship directed SEBI to file a report, my lord.
Your Lordship, in this case, Your Lordship, similar instructions, Your Lordship, already investigation process is underway. Your Lordship, we'll be able to file a report within 2 weeks, Your Lordship. That is
On the prayer of SEBI, matter will appear in the monthly list of April 2024.
Much
My lord, can it be March, my lord? My lord, can.
Direction.
If Supreme Court is monitoring the thing, why should we entertain the writ petition here? So they are outside India. Then if the Supreme Court direction is there and the Supreme Court is monitoring the repayment schemes, how can we entertain the writ petition? No, Mr. Chakraborty. You are for?
I'm for the respondent number 1, Millard, the Ministry of Corporate Affairs.
Ministry of Corporate Affairs.
They have been made a part.
Are you is SEBI is there?
Sir, my lord, presently, when Honorable Supreme Court is
Please place on record a short affidavit disclosing that the Honorable Supreme Court is overseeing the entire exercise. All these things are not our headache. Mr. Chakraborty, take a leave from the Supreme Court approaches. All right? We are keeping it on the prayer of the parties. Adjourn monthly list of April. Next. Vishal.
My lord,
Yes, SEBI shall submit report by the adjourned, within the adjourned.
my lord, I beg to appear for the petitioners in item number 102
My lord, here the petitioners are, my lord, takes up 102. My lord, on the last occasion, this particular matter appeared. My lord, I prayed, my lord, this should come up with one of the main matters that my lord is hearing. Roompa Bishas, that is also pertains to Vishal Group, where we have made certain applications.
Give that number.
Yes, I have already handed over. It's WPA 13162 of 2015.
List along with so and so.
My lord, I beg to pray, my lord, for an interim order to the extent that, my lord, the auction notice which has been published, my lord, it way back in July 23, my lord, that does not describe, my lord, the land properly. My lord, B3 describes the land, there is a building, the petitioners are, my lord, bona fide purchasers of that building. My lord, to that limited extent, if this be stayed, otherwise, my lord, that is, and my lord, a similar order had been passed by an honorable single bench of this court. If I may hand that over, my lord, where SEBI has submitted that they have not gone ahead with the auction and not considered, my lord, this particular property. If my lord kindly has a look at that, that is why. My lord,
your other matters are coming.
My lord, if it can appear on 22nd, my lord, because last occasion also, my lord, directed somehow the file is not.
Or like 22nd, your matter will come up.
My lord.
Also, Mr. Banerjee, take instruction in respect of his petition. So you are appearing.
I am appearing.
Take instructions with regard to what he is saying.
Yes, Your Lordship, I agreed with that. In another matter, Kakoli Shortcut and others,
Yes.
WPA 18967, the direction had been passed by this learned court that they can make a representation before SEBI and SEBI shall take the same into consideration with regards to those properties. Your Lordship, I am praying that the same direction be passed in this matter. I am just handing over the orders, Your Lordship. Exact same facts, Your Lordship.
But kindly has a look at paragraph 7. That is what I am relying on. Passed by a single bench.
Give the writ petition.
Your Lordship, if you kindly takes up paragraph 10.
Let the writ petition be placed before us. Yours relate to which lot number? Your issue relates to which lot number?
B3, my lord, that is in the notice. That's at page 145 of the petition.
Lot number B3.
B3, my lord. That is the same. Only one thing, my lord, there it has been recorded that they could not show, my lord, documents to show their ownership, my lord. Whereas I have, my lord, annexed all the deeds here, my lord, that pertains to, my lord, other owners.
Petitioner. No, কেটে দাও, we're disposing of the writ petition. Petitioner claims to be the bona fide purchaser of apartments. Petitioners, more than one petition.
Yes, my lord.
Petitioners claim to be bona fide purchasers of apartments situated at G4 apartments in a G4-storied building, namely Priti Panna apartment at so-and-so, hereinafter referred to as the apartments. Hereinafter referred to as the petitioner's apartments. Claim to be bona fide purchasers of the, they had purchased, it is pleaded they had purchased the claim corner. Petitioners are the bona fide purchasers of so and so. Deeds of purchase deeds are annexed to the writ petition. It is the it is the grievance of the petitioners. It is the grievance of the petitioners that Honorable 31st of July 2023 notice was issued So this is under recovery proceedings.
Pursuant to my lord recovery proceedings of SEBI.
Huh?
Pursuant to recovery proceedings of SEBI, yes, my lord.
SEBI recovery proceedings.
Yes.
I see. It is pleaded on 31st July 2023. Notices were pasted outside the premises disclosing auction notices were pasted outside the premises.
My lord, if I may only, that auction notice is dated July 12, 2023.
No, on 31st July it was pasted.
It was pasted, yes.
Auction notices dated 12th July 2023 were pasted on the walls on the periphery of the premises, disclosing auction of the property to recover dues of respondent SEBI. Full stop. But these properties have been sold prior to the SEBI proceedings or in 2014.
Yes, Your Lordship. The problem with SEBI was SEBI did not have that information with regards to these particular properties having been sold. In a similar case, in that Kakuli Sarkar case, when this was intimated to us, we took action. And I'm praying, Your Lordship, a similar order will pass. SEBI undertakes, SEBI will take action.
SEBI, in respect of recovery certificates bearing numbers 1587 of 2018, 1588 of 2018, 1589 of 2018, and 1599 of 2018, issued against respondent company, namely Bishal Abashon India Limited and one Ratan Choudhury. Full stop. Petitioner contends that the apartments, petitioner contends they had purchased the apartments prior to in 2014, prior to the issuance of the recovery certificates and prior to the issuance of the recovery certificates. Full stop. Hence, learned counsel for SEBI submit that his client was unaware that the petitioners are owners of the apartments in the premises in question. The auction notice has not been given effect to as yet.
With regard to this particular property.
With regard to this property. Only these apartments.
This B3 group, Your Lordship, this group has not been given effect.
Auction notice no,
they were not aware, and the lot bearing B3 and the property in question and the auction notice and the auction in respect of the property in question was not successful. Full stop. Under such circumstances, we dispose of the writ petition, directing the petitioners to place on record their title deeds before respondent SEBI, and upon perusal of the title deeds, and upon perusal and being satisfied with the, and in the event the said respondent is satisfied with regard to the authenticity of the title deeds relied upon by the petitioner, their properties, the properties claimed by them shall be kept apart, shall not be put up for auction as a part of serial number B3 in the impugned auction notice in future, in the impugned auction notice. Full stop. With this direction, writ petition is disposed.
My lord, with the affidavit of service may be given.
Affidavit of service is given.
Only in respect of this company, I have made certain
Obligation, Lord.
I have already handed.
They will come up in March.
Yes.
Yes, next.
Plan for the petition. Yes, my lordship, earlier
I have just received the application, I need something.
Learned lawyer for SEBI shall submit report with regard to the affairs of the company and specify whether the affairs of the whether such affairs were in violation shall submit report whether the company was carrying on illegal was running illegal collective investment schemes in violation of law or not. Full stop. Report shall be filed in the monthly within 6 weeks. All right, matter will appear in the monthly list of April 2020. Yes, next.
Lordship, in this matter, paying for the petitioner, Lordship, over here the petitioners had invested in one real estate project of the Saroda Group. Lordship, thereafter the group entire got embroiled, after which, Lordship, we made representation to all authorities. SEBI replied to our complaint and stated that you make this complaint before the Honorable One-Man Committee, the Honorable Justice S.P. Talukdar Committee. We made representation over there, but that is getting refused because they are saying that a court order is required, Your Lordship. My only prayer is that, Your Lordship, I have already made the representation that be considered, Your Lordship.
Receive the copy of
Give copy to
Lordship, I shall serve the copy in the course of the day, Your Lordship.
109 of the
8.
Of the matter that Abdul Khalid an order was passed. There, an application, the matter was referred to the one. Now, one saying that particular claim has been referred, not the entire. The problem is this Abdul Khalid on the other. All the orders were passed. It is lying before the election of the Chief Justice. Probably the ED has made an application for appointment. That was granted by the Lordship. Unless the recalling application cannot be taken. Since the order was passed.
Let us wait.
I have to make an application.
My lord was hearing the main Sharoda matter.
Before the assignment to the Chief Justice.
Let us wait.
Lordship, if I
we will keep it in the monthly list of March, and then the main Sarada matter has to be assigned. If it is assigned to us, we will take up your matter.
Can an order be passed, Lordship?
Matter will appear in the monthly list of March. Next.
Great.
Lordship, in this matter, I'm praying for not today, Lordship.
Monthly list of April 2020.
Much obliged.